Good afternoon, everyone. Welcome to the Appellate Division First Department. We have oral arguments for today, January 27. I didn't think all you guys would brave the snow. I was assuming everyone was gonna, no one was gonna come and we'd be all by ourselves. But thank you for coming. We appreciate it. So please, again, as you probably know, ask for the time that you actually need in order to get out the salient points of your arguments. We have read your briefs. We are fully familiar with your arguments. The red light is for you, not for us, in that if we have additional questions to ask, we will certainly do so after the red light. People v. Elvin Pacha. That matter is submitted. Stuyvesant Town v. New York State Division of Housing. Five, 3, 5, and 4. Matter of MG Children. That matter is submitted. Carreno v. Chelsea Leaf. Who's the appellant? Is there an appellant here? Did you wish any time for rebuttal? Respondent? 5 and 2, 5 and 2. Koch v. Jean Baptiste. That matter is submitted. People v. Jordan Hernandez. That matter is submitted. People v. Anonymous. (615). People v. Joseph Garrett. That matter is submitted. Kinsey v. Amazon. Who do you represent? I'm sorry. I have Amazon. Sure. 4. Rowdy v. Alejandro E. I'm sorry. Rowdy v. Alejandro E. That matter is submitted. Patchell v. Gordon. That matter has been adjourned. People v. Muhammad Quatabi. Who do you? Oh, I'm sorry. Yes. 626. Sinkler v. Muhammad. Both matters will be called together, and both matters are submitted. Torres v. 40 East End Avenue Associates. 525. People v. Angel Nieves. 626. Cummings v. the City of New York.
Appellant, 5 and 3, please.
525. AG1 Doe v. Morris.
Appellant, Your Honor, 9 and 3, please, on this constitutional issue.
6, 2, and 5 on this constitutional issue. Laquan Brockington. That matter is submitted. People v. Kelvin Valdez. That matter is submitted. Ma v. Wang. Both matters will be called together. 525. First case for argument is Stuyvesant Town versus New York State Division of Housing. Whenever you're ready.
Good morning, good afternoon, Your Honors, and may it please the court.
If you could please put the mic down a little bit and speak into it so everyone can hear.
Yes, good afternoon. May it please the court, Michelle McGinnis from Collins, Dopkin, and Miller for petitioner appellants. This appeal turns on a single question of law, whether DHCR may approve an MCI rent increase when the Rent Stabilization Code expressly requires the owner to apply for a waiver and no waiver was ever sought.
That's only if there was a prior MCI rent increase within the useful life period. And it is undisputed on this record that when the landlord put in an intercom system in about 2002, and then put in the newer one in 2014, within the 15-year useful life period, the landlord never sought a prior rent increase. And if there was never a prior rent increase, then the whole waiver issue is not even implicated.
Right, that is DHCR's position. The rent
Well,
stabilization,
Directly into the mic.
that is DHCR's policy.
And they've been consistent.
that
They've
policy-
been consistent about that.
Right. And meanwhile, the rent stabilization code consistently says that a waiver is required, quote, where no previous increase was granted, unquote. And it says it throughout the waiver provision. There's a waiver, and then there's two circumstances by the plain language of the code that a waiver is required. One is if there was a prior MCI. The other, plain language, is when there was no prior increase. That's the specific text of the, it's rent stabilization code 2522.4, subsection A2, clause E, 3, 4, talks about replacement of an item that's proven inadequate through no fault of the owner. And it says, provided there has been no major capital improvement rent increase for the item requested. So throughout the code, it explicitly covers two circumstances. One, where an owner had a prior MCI, and another expressly, quote, where no prior increase was granted. This is the issue that the
Is your argument that a request for a waiver is required where there was no previous MCI?
that is exactly what the code provides.
So your reading of the code is that there would never be a waiver because there would always either be an MCI or not.
No, this is for a prior, if an item is being replaced within its useful life, a waiver is only required if an item, right, every item has a useful life. If an item is 15 years and it gets replaced at 12, that's within its useful life. What the code expressly provides is that if there is a replacement of an item within its useful life, a waiver is required. It's mandatory. And then DHCR, the code goes through and DHCR can process that application depending on whether there was a prior MCI or depending on whether there was not a prior MCI. It's the way the code is written. So yes, so if DHCR were to grant the waiver, of course, under the code, it doesn't mean there's an automatic MCI granted, but if DHCR grants a waiver and an owner did not have a prior MCI, the code provides that DHCR could grant 100% of the MCI. They could otherwise prorate it depending on what the,
Counsel, there's got to be a logic to first of all, we defer interpretation to an agency based on our case law. You understand that?
I do.
Okay. And logically, if for some reason the landlord was compelled to replace a particular capital improvement within its useful life, then it makes sense. And if you already got a rent increase for it, then it makes sense to say, well, why are you doing it again within a certain period? So therefore, maybe there's something special about the new one better than the old one for some reason, and therefore you need a waiver. But if there's never been a rent increase for the item in issue, why do you need a waiver?
Okay, so there's a few circumstances. For example, what if an owner has a new building that becomes subject to rent stabilization? Never got an MCI because wasn't subject to rent stabilization. Under DHCR's policy, that owner, once they're under the jurisdiction of DHCR, could rip out all the building systems because there's nothing saying they can't, and reinstall them just to raise the tenant's rent. If the purpose of the law is to prevent unnecessary rent increases, it's unnecessary that tenants pay a rent increase for an item that is still living, it's still within its useful life. And I do want to
Just,
my red light is on.
why don't you deal with the other points on rebuttal? Who's going first, DHCR?
Court, Christina Ossie from the DHCR. The court in Tammy Brake, which is a decision that we have mentioned in our papers, has specifically.
Counsel, was your adversary's reading of the statute accurate?
This is a regulatory creation. There's nothing in the statute on useful life. This is something the division itself had promulgated many years ago, and it's in its regulations. And the interpretation we disagree with, and the Tammy Brake decision rejects that interpretation. That DHCR's interpretation is consistent with the regs. The sections from which my adversary is pulling out certain excerpts didn't apply to the facts of this particular case. They could be called into play in some instances when there's painting and waterproofing, and some of the building is done and some isn't, and there may be some sections for which no increase was requested, but then the useful life comes into play in some way. But in this particular case, as Justice Shulman had pointed out, this was an example. This was a situation where an intercom was completely not done piecemeal and not done unnecessarily. It was upgraded to a color video intercom system building-wide in 10 separate buildings in this complex. It's undisputed, it never got an increase for the pre-existing intercom. And then it applied after the installation was done in 2014. Within the 2-year period it was required to file, it did. And in 2016, it got an increase. And according to the record, the one application shows, or the orders show, that it was, at least for one of the buildings, was a $2.14 per room per month increase. Now, the tenants are arguing the owner should have filed for a waiver because the useful life had not yet been exhausted. But, you know, we have orders showing that the agency has consistently found that where there's no MCI granted, that it is not necessary for the owner to file a waiver. And the court below upheld this reasoning as rational, and the standard for an Article 78 is whether it's rational, not whether someone can interpret it differently. So we ask the court to affirm the lower court decision. Thank you.
Whenever you're ready.
Good afternoon, Your Honors. May it please the court. My name is Anthony Moriali of the law firm Belkin, Bird & Goldman on behalf of the building owners here. I want to just quickly touch 2 points. Much of what I would have said has already been said. So the tenant appellants in this case are presenting the case as merely one of regulatory interpretation. But in respondent's view and my client's view, the case turns actually on a simple but necessary principle of administrative law, and that is regulated parties must be able to rely on the long-standing and consistently applied policies of the agencies that regulate them. Without that, administrative law, regulatory law falls apart. In a regulatory environment as complex as rent stabilization is in New York City, predictability cannot be an option. Owners must be able to understand the rules before they invest millions of dollars into building-wide improvements, and New York law is clear that when an agency suddenly does an about-face and goes against its own precedent without explanation, it's engaging in the very definition of arbitrary and capricious agency action. So what the tenants are essentially arguing in this case is that my client was supposed to predict that DHCR would change its policy in 2014 before they began work on the MCIs, because an MCR waiver, where it's required, must be filed before work is commenced. Otherwise, tenants state correctly, you lose the opportunity to do so. So here what happened is that DHCR followed its precedent. Respondents followed DHCR's rules. My clients followed DHCR's rules. And appellants are essentially asking the court to impose what is a retroactive obligation that could not have been foreseen and that DHCR did not announce. And I'd also like to observe that there are likely other applications which are currently pending before DHCR where owners did not file waivers based on the same understanding that a waiver was not required, which if you find for the tenant appellants, you will invalidate those applications because the time to file those waivers has run. The second point I want to make, and again it's been touched on already briefly, is a point about source of law and deference that's required. This is entirely a invention. The useful life provisions are entirely an invention of DHCR. The rent stabilization law has been amended many times since the MCI increase was authorized by the legislature, and not once has the word useful life or waiver appeared in those provisions. And so a recent case from the Court of Appeals just reaffirmed the standard in these situations, matter of LL 410 East 78th Street, where an agency interprets its own regulation in its technical domain. The question is not how the court might read the text in the first instance, it's whether the agency's reading is rational and consistent with the regulation's purpose. And that's essentially what happened here. DHCR looks at these regulations and has said that the purpose is to prevent repeated MCI increases. They applied that exact purpose in this case. So in summary, in accepting tenant's position, you would produce an extraordinary result. It would mean that DHCR has been misreading its own regulation for decades, that the courts were wrong to defer to that reading, and that owners had to be expected to second guess that settled agency practice every time they undertook an MCI project.
Thank you.
Thank you for your time, Your Honors.
Okay, just a few things. One, as far as reliance that counsel talks about, we remember the Roberts case where also DHCR relied on its own internal policy that was subsequently overturned because it was in conflict with the plain language of the statute. This is the same situation here.
There's no statute.
No, well, actually, just, no, well, this is a regulation, but
And,
as far as,
in the wages decision, there was a decision, I believe, in dicta where Supreme Court made clear that, in dicta though, that this is, eventually we heard this case, 185-83rd 446, where the very rationale for the waiver is only if there was a prior MCI increase within the useful life period. That didn't happen here. So it doesn't seem to make sense for a landlord to invest millions of dollars or hundreds of thousands of dollars in an MCI to not get a fair increase under the law.
so there's nothing in what we're saying that would prevent a landlord from getting a fair increase. The rent stabilization code expressly provides that if they didn't get a prior MCI, they could get 100% of the replacement costs, right? They don't have to have a prior MCI to get 100% of the
There has
replacement
to
costs.
be, the landlords have to be able to rely upon what has occurred in the past. Because if DHCR all of a sudden changed its position, that would be arbitrary and capricious. They have to be able to rely on what they've done. This is what DHCR has always done.
Similarly, the general public should be able to rely on the regulatory text.
And also to rely upon what DHCR has done in the past as well in terms of these MCIs and the requests for these MCIs. But thank you all.
Okay, thank you.
Carano v. Chelsea Leaf. Whenever you're ready,
Thank you. May I adjust this a little bit?
please.
Thank you. May it please the court, my name is Mark Wellman. I'm with the firm of Marshall Dennehy. I represent the defendant third-party plaintiff appellants, the Chelsea Leaf South Housing Development Fund Corporation, 8th and 7th GPLC, and Chateau GC LLC. This matter concerns an incident that occurred on 211 West 28th Street on November 21st, 2016. The plaintiff was working inside a debris container.
Yes, and so he was loading the debris onto the dumpster, and he allegedly stood on top of the dumpster as he's putting the materials in it, attempting to put the tarp over the dumpster. A gust of wind blows him off. So the question is, what?
Your Honor, we contend that contrary to the decision at the trial court level that the plaintiff never met his burden on summary judgment on Labor Law Section 240, parentheses 1, there is a select few of these.
But is there anything in the record that states that in order to place the tarp over the dumpster that you had to actually stand on top of the dumpster and the tarp and slide it? I think he said it was like putting a sheet on a mattress, something of that nature. Is there anything in the record that says that is the way in which this has to be done?
No, Your Honor. In fact, I was present at all the depositions in this case, and when we went through it in detail with the plaintiff, he said that he went on top of the dumpster to do this, but more importantly, that his coworker was standing on the ground to do it. And this is coming from the plaintiff.
Well, he did also say that he had observed other workers putting the tarp on because they did this at the end of every day's work, and that he saw other people standing on top of it. And sometimes people would be on the ground level spreading. So it seems like both ways were possible and were accepted and were seen and were known to be used at the work site.
Well, if I may, Your Honor, there's significant testimony from an eyewitness, Mr. Pauta, who is his coworker, and he denied that it was required at all to go up on top of the dumpster and cover it in that fashion. In fact, both Mr. Pauta and ultimately the Flatiron owner and the Flatiron superintendent, the construction managers for my client, said if they'd seen anybody doing that, it would have been improper, and no one should be on top of a dumpster tarping it in that fashion. The plaintiff contended that he was directed to do it, but when I cross-examined him on this point, there was no one that said, he never said that anyone directed him specifically to go up there. He just took it upon himself to go on top of the dumpster.
But at most, it seems, but I understand your argument that therefore plaintiffs shouldn't get summary judgment. But it seems to me that what you're describing creates a question of fact that would also properly prevent you from getting summary judgment.
Well, Your Honor, we contend that Court of Appeals' decision on this point is quite clear because the issues of fact that were raised were on a self-serving affidavit at the
I'm sorry, every affidavit is self-serving,
Well,
counsel.
put it this
We
way.
can't reject tell me about an affidavit that isn't self-serving.
Well, Your Honor, in the Ortiz case, we pointed out there was a burden shifting in that case, and it involved a dumpster. And in that case, Your Honor, we pointed to the
Not answering my
specifics as there was an affidavit that was submitted, Your Honor, after the close of depositions, and that wasn't enough to carry the burden. So my position is, Your Honor, that the burden was never met. If there was testimony that came forward under cross-examination, under oath, eyewitness accounts that someone specifically directed, instructed, and told this person to get on top of the dumpster, it's the only way he could potentially tarp it, and that's the only way he should have been doing it.
I
That would be the
understand your
case.
argument as to plaintiff's motion for summary judgment, but it seems to me that your argument also sinks your motion for summary judgment because it essentially says there was an issue of fact about how you were supposed to cover the dumpster.
Your Honor, I believe the cases we cited closed the door on that, and that if the
I don't
plaintiff-
see how. One, he testified that this is the way he was told to, that it was what he did, what he'd always done, and he'd seen other people doing it. You don't have you don't have any testimony about a safety meeting at which everybody was told that that's not the way to do it. Your testimony is kind of soft.
Well, Your Honor, if I may, the plaintiff, I believe, testified he was about a little over 5 foot, and the dumpster came up to chest level. So
That's not what
The
we're
amount of
talking about.
covering needed would
That's
have been
not what
from
we're
the top.
talking about. What we're talking about is whether or not that was an accepted way of putting on the tarp.
Understood, Your Honor. With my time, I'd like to be able to discuss the indemnity portion. On that specific issue, Your Honor, there is no word negligence in the contract at all. There is no negligence trigger. This is, in fact, the language out of the contract, which we cite to, the operative language is in connection with the work. Flatiron were the eyes and the ears of my client.
Your position is at least you should get a conditional grant of.
Your Honor, if there's any finding, any issues of fact that go to trial in this case, then it must be an immediate trigger on that indemnity. Full lock, stock, and barrel goes to Flatiron, Your Honor. In this particular case, Your Honor, we have not only the testimony from the president of the company, but also from the site super on site that they were there doing daily walkthroughs.
This is
and
for
daily-
Flatiron?
Yes.
And I think don't they concede actually that it was their duty to oversee the safety on the project?
Yes, Your Honor. And in fact,
And also they had the ability apparently to stop work if in fact there were any violations of the, what
Correct.
was to be done?
without a doubt, in 200 in common law negligence against my client was dismissed. There is no fault on the owner or the general contractor, which leaves the question of if anything survives, who is to blame? And it cannot, as operation of the law of the case, be my
So
client.
your answer to the question about whether you're seeking conditional indemnification, if that's appropriate, is what exactly?
That there must be full indemnification for my client if any portion of plaintiff's claims survive. So if that's the conditional element, then yes. But if we contend that the plaintiff's case can't survive, but if any portion of it does, they must 100% indemnify our client under the terms of the contract.
Thank you. You do have time on rebuttal. Thank you. I'm sorry, do you? Yes, you do.
Good afternoon, Your Honors. May it please the court, John Shaw for a plaintiff respondent. As Justice Gessmer pointed out, my client did testify in the record that not only was it the custom and practice that he saw the workers throughout the time he was there, which was approximately 6 weeks, standing on the dumpster to secure this very long
These were
tarp.
unknown individuals who he had seen do this. And also he stated that he had been told by an unknown individual to stand on the tarp, right?
It does not matter,
Well,
respectfully, Your
what
Honor.
about, is there also an issue as to whether or not the task could have been accomplished without standing on the tarp, standing on the dumpster?
Actually, my client testified that actually, essentially unequivocally, that is how they had to do it. And he testified
Based
in
on
the
what?
record, and he said that it was the custom and practice of the workers, which goes line in line with Biacco Nato, the Court of Appeals case, where there was actually a blatant disregard by the subcontractor of the GC's warning.
In order to sustain your burden, don't you need more than simply your client's testimony that that is the way in which the task had to be accomplished? Don't you need some other testimony, engineer's report, something else to back him up?
Especially in
actually-
light of the
I'm sorry.
evidence, especially in light of the evidence in the record that there were other individuals who did not complete the task that way, such as the coworker who was on the ground level.
First of all, in the Bush case, which this case is very similar to, in the plaintiff respondent's
But in the
brief,
Bush case, he was required to get into the dumpster to complete the work. We don't have any information on the record here that completing the covering of the dumpster required him to step on top of it.
it's the same thing with any ladder case or any scaffold case, that you don't need corroboration.
Well,
Plaintiff
it's not about needing corroboration. It's about what the work to be performed requires of your client.
Plaintiff testified that he was required to stand on that dumpster. There were no safety meetings.
Based upon what? I recognize that this was his testimony, but again, my question is that sufficient? Why is that sufficient? Again, as my colleague mentioned, wherein the task apparently was completed by others by standing on the ground and not standing on the tarp, on the dumpster.
Well, it is based on what Mr. Poulter said. Plaintiff testified that he was directed to do it. Not
By an
only was
unknown
it the
individual.
but it does not matter because Mr. Poulter even said he was not the person in charge throughout this entire time. In page, I think, 433 of the record, he said there was no one in charge other than Mr. Pimentel, who was the foreman. This goes line in line with the Bush case where—
No, because as my colleague stated, Bush v. Goodyear specifically stated that there was a determination that they were required. He was required to do so. Here, there's no showing that plaintiff was required to climb on top of the tarp on top of the dumpster in order to pull the tarp.
Plaintiff testified, and there was nothing to controvert that he wasn't required other than Mr. Poulter, who said that at times the workers supposedly were on the ground. He never even testified that he was never asked whether or not on other occasions were workers working on top of the dumpster.
Well, you say supposedly there were workers on the ground, but at the time of this incident, there was actually a worker on the ground.
What I'm saying, Your Honor, is that Mr. Poulter testified that he observed on other occasions workers on the ground securing the tarp. He was never asked, did you ever see throughout your time at this job site workers being on top of the dumpster? He was never even asked that. Notwithstanding that, there were no safety meetings on this site. Notwithstanding that, they conceded there were no safety railings on this dumpster, which is the same exact dumpster as in Bush. 6-foot dumpster, give or take, identical dumpster. There's no distinction. And the reason this—
Distinction, again, is that in Bush, the plaintiff was directed by his supervisor to climb on top of the dumpster. You have time on rebuttal.
Good afternoon, Your Honors. May it please the court, my name is Lee Tarr, and I represent the respondent, Flatiron. We're asking that this court affirm the lower court's decision, finding 2 issues of fact, or questions of fact, whether the work performed by Flatiron was in connection to the plaintiff's claims, and whether there was a negligence or an act or omission that was required. Flatiron is the construction manager who contracted directly with the owner, non-party 8th and 7th limited partnership. The owner also contracted separately with the appellant Chateau, who then contracted with the—
You're Flatiron, right?
Yes.
And weren't you in charge of the safety at the work site?
We were in charge of the scheduling, the contracting, the scheduling and the arrangements of the
What about
timing.
the safety?
But there was some safety, yes, as was Chateau, who also had the right to shut down work if they found any conditions.
But you specifically budgeted and contracted for appointing a special safety director.
Yes.
And it was part of the budgeting you got in this area, and it was acknowledged that that safety director had a responsibility, correct?
Correct.
And you also agree with— do you agree with your friend or disagree with your friend that the indemnity language is very broad here and there is no negligence trigger?
I highly disagree that it's very broad, because it requires some sort of finding that there's a connection to their work, which they were not responsible for the subcontractor, the contractor.
Any act or failure to act on the part of Flatiron in connection with the performance of the services hereunder.
Yeah, but there hasn't been any finding, and there's a question of fact on if they did have any act or failure in their admission. Like there's been no determination that they didn't perform their safety duties. All the parties testified that nobody ever saw Epiphany workers on the containers. That was never something that came to their attention. So they didn't have
But there was testimony that there were people working like this periodically. I mean, there is testimony in the record that talks about that. The fact that your people never saw that doesn't, mean that they never were on top of the dumpsters working.
But under the contract, they would have a reasonable, they have to have some sort of reasonable reason to know in order to inform the owner as well. So that's their requirement. And Chateau was still responsible fully for their subcontractors, which was Epiphany.
Thank you. You have 2 minutes on rebuttal.
Thank you, Your Honor. It won't need quite that much. Going to Flatiron first, Your Honor, I think it's pretty clear that if there was any accident on this job site, it was in connection with the work.
Could you speak into the mic?
Oh, I'm so sorry, Your Honor. And in fact, as rightly pointed out, as part of the contract in Article 4, which is 3.13, there is a budget line item that they're responsible for, a safety coordinator for $3,600 per week, excluding Saturdays and Sundays. For certainly that element, safety isn't entirely part of their agreement and what they agreed to.
Oh, it's a contractual obligation.
Correct, Your Honor. And pictures of this container, I think if there's anything that's more compelling, is this accident happened on West 28th Street. It's the only way in and out of this construction site is by going by this dumpster. So if we're to believe the plaintiff in his theory that this is a custom and practice, they're going on top of the dumpster all the time. Flatiron's got daily walkthrough responsibilities. This dumpster is enormous. It takes up multiple parking spots in front of the building. If they're doing their job, wouldn't you think they'd see the plaintiff and coworkers climbing up and down this thing, which by their own testimony from their president of their company and their superintendent said, if we saw anyone up there, we would absolutely tell them to come down. It's dangerous and it's not appropriate for safety. How could you miss that? So if there's connection with the work is obvious.
Well, the dumpster was being covered at the end of the workday, right?
It has to be uncovered and recovered every day. And they're putting trash in there.
Beginning and end of the workday?
Your Honor, I don't know the exact timing of when they came in and out, but for certainly daily walkthroughs, the eyes and ear of the ownership. If we're to believe the plaintiff, and this is like a real problem that people are on top of this dumpster, I'm not sure how Flatiron's representatives getting paid over $500,000 is what they agreed to could miss what's going on in this dumpster on West 28th Street on a multi-month project. Thank you, Your Honor.
Thank you. Excuse me. Thank you all. People be anonymous. Yes, please.
May it please the court, Alexandra Mitter for appellant. My client was abandoned by his attorney during a proffer session. There's no dispute about that. There's also now no dispute that a proffer session is a critical stage at which the right to counsel attaches. Under Chronic, under this court's decision in Struthers, under the Third Department's decision in Cipriani, that's the end of the inquiry, because the law is clear that prejudice is presumed where we're talking about a complete absence of counsel at a critical stage. And that's what we're talking about.
Is there any case law suggesting that when an attorney does not attend a full proffer session or doesn't show up at all at the proffer session, that the conviction is still good?
There's nothing that says the conviction is still good, Your Honor, and that's because we presume prejudice where counsel is not present for something that the law has held, which respondent has conceded is a critical stage of the proceedings. There's no question that a proffer session here is a critical stage of the proceedings, and there's no question that the lawyer wasn't there. And we presume prejudice because we've already called it a critical stage, and the Sixth Amendment already tells us that counsel is essential. So we have to presume prejudice. It's a lot, the logic holds. And I think this
Counsel,
court
what
said
was the effect of the information gathered at the proffer session? How was it used at trial?
So most obviously, my client made an admission of guilt to the charged offense here that was introduced against him at trial. That's an obvious point of prejudice. That's prejudice that's the only type of prejudice really that respondent kind of acknowledges. But the problem here with a proffer session is that the prejudice is so multifaceted. It's not just about making sure your client doesn't say incriminating things. That's the purpose of a proffer session, is to make sure your client says those incriminating things in a helpful way. Client's supposed to be preparing their client. I mean, the attorney's supposed to be preparing their client for the proffer session. They're supposed to be.
The question was there anything stated during the proffer session where counsel was not present, which was used against the defendant at trial?
Yes, Your Honor.
And what was
absolutely.
that?
It was that he was there and committed the robbery. He made a complete confession to the charged offense, which was introduced against him at trial. And it's hard to,
And it was in the context of trying to explain the proffered information that he thought would help him in terms of the gun running and the creating silencers for guns in Brooklyn, correct?
that's correct. He was there proffering on a different case. He had no reason to be talking about the case that he was charged with, but because his lawyer wasn't there and because he wasn't prepared to proffer effectively, he made this huge admission that was admitted against him in at trial.
So for 4010, which allows the attorney to explain himself in terms of whether he did something strategically or exercising something in that context, can you shed light on this so-called custom and practice of attorneys, as in the attorney here's case, where they don't want to expose themselves to potential conflicts, and it seems to be the culture to step out of the proffer session if it's unrelated to the very issues he's representing the client for. Can you explain that?
I would love to be able to try to explain that, but as someone who has prepared clients for proffer sessions, that is maybe the custom and practice of this particular attorney, but that is not the custom and practice of attorneys writ large. The New York Bar Association recommends specifically
Was the
against
attorney
doing that.
present at a part of the proffer session?
The precise moment at which he left is not exactly clear. I think everybody agrees that he was there when the proffer agreement was signed. How much longer he stayed after that is a little bit unclear. The attorney said he left when matters turned to this other matter, and from the notes of the proffer session, we know that that happened almost immediately.
And
we have-
was there,
Go ahead.
was there anything, anything that we could take from the fact that there seemed to have been some kind of a discussion between the 18B attorney, the defendant's attorney, and the DA at the time? Do you think I should stay? Nah, I don't really think you need to stay. Okay, you're going to go, you can go. I mean, it seemed as though, sort of follow up on what Justice Schulman said, that it was sort of, oh, no, you know, you don't really have to stay for this part. It seemed almost like expected that he wasn't going to stay from reading the decisions and the record.
Yeah, I mean, what happened, what the attorney initially said happened was that I was asked to leave and so I left. When the prosecutor kind of bristled at that and was
He
like,
said
whoa,
no.
whoa, I didn't ask you to leave, then the lawyer starts to say, well, we talked about it, you know, sometimes I leave, it was about this other case, I didn't think I needed to be there. I think the reality of the situation is the one that the lawyer said in the first instance, which is I was asked to leave, so I left. And ultimately, he didn't know there was a constitutional right of his client to be there. That's really clear in the record. The lawyer did not
Yes, I
know
heard him- I
this
saw
was a
him say
critical
that.
stage at which he had a right to be there for his client. And ultimately, whether the DA and the lawyer were in agreement that the lawyer should go, that's not their call. It's my client's call because it's his right to counsel, and he was denied his right to counsel, whether it's because of this sort of side door dealing between his lawyer and the DA, or because the DA asked, or because the lawyer decided of his own accord. Ultimately, it's a decision that's reserved to my client, and there's no question that there was no waiver here, no written explicit waiver, which would otherwise be required to waive counsel at a critical stage.
So excuse me, back to the trial testimony. This was a bench trial.
Yes.
The testimony that was elicited at the proffer session, that testimony came in on cross-examination, did it not?
It came in on cross-examination and rebuttal, Your Honor. A witness
But was
called.
there not a determination by the court that it was because the door had been opened and that's why the testimony was allowed?
Yes, there was a determination that the door had been opened in that they were allowed to impeach my client with his prior inconsistent statement admitting to the crime. Ultimately, regardless of how or why that information was introduced, there's no question that it was prejudicial to have a confession to the crime that's being tried come in at
Had
trial.
his counsel been with him at the proffer session, then presumably there'd be no door to open.
That's absolutely correct. And I think ultimately the real prejudice here is that had my client had the effective assistance of counsel, had any counsel at all at this proffer session, there might not have been a trial because counsel's there to make sure this proffer and the cooperation happens successfully. And
We
he might
don't
not
know
be
what
here
the, we don't know what the agreement was, do we?
what
We don't know what the agreement was. I mean, we don't know whether counsel spoke to the client concerning the information. We don't know whether there was what exactly was going to occur, whether there was going to be a grant of immunity, whether or not these charges were going to be dismissed. Do we know any of that?
Well, I think we certainly know that the lawyer did not talk to my client about the substance of the proffer prior to the proffer session. That much is very clear in the record.
Well, let's just backtrack on that, though, right? The client was really driving the bus here on the proffer. He had called a number of agencies looking to provide information, right?
Yes,
And that's how this proffer session came about.
Yes, because my client, an elderly homeless veteran, was doing sort of anything he possibly could to try to get out from under the absolutely draconian mandatory minimum of 16 to life
But the
in
point
prison.
is, he was doing this on his own. He had set this up on his own with the district attorney, the assistant district attorney.
He reached out to set this up, but he didn't schedule it. I mean, the man's in jail.
Right.
The lawyer was there, knew this was happening. It's completely inexcusable that he would find the topic of the proffer to be a surprise when he showed up at the proffer session. That's absolutely
Well,
inexcusable.
when your client reached out to the assistant district attorney, I mean, it was that he had certain information which would be fruitful to them. So, I mean, we knew what that information was going to be.
The DA knew and my client knew, but his attorney did not. His attorney was quite clear. He did not speak to his client prior to the proffer session, did not know the topic of the proffer session, thought it was a bad idea, but didn't do anything to prepare his client.
Because this is what your client wanted to occur.
He wanted the proffer session. He didn't want an uncounseled proffer session. He wanted successful cooperation so that he might have the chance to not die in prison, which is where we are right now.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Caroline Williamson for the people. We just have a few factual disputes with the record that was laid out here.
Regardless of your factual disputes, right, it's ineffective for counsel to not be at a critical stage of
And that's the
case.
dispute, is that he was at this critical stage.
He left.
He was there for far longer than she said. He was there for at least an hour, and he prepared him in advance. Without the prosecutor present, counsel and defendant sat together while counsel walked him through the proffer agreement and told him specifically that if he said anything at this proffer agreement and then later chose to testify inconsistently at trial, that could be used against him.
And that's,
Go ahead.
go ahead.
But he left before, for example, the defendant made the, admitted to the crime which was at issue, correct?
Yes, he stayed for an hour while they discussed the crime that was relevant to these charges. And then after the topic had changed to the gun running, counsel, and we have this evidence from the record of the 440 proceeding, he did not want to be called potentially as a witness against his own client.
So let me ask you the same question I asked opposing counsel. Is there any case law where defense counsel leaves in the middle of a proffer session, and when defendant then challenges his conviction, that it's sustained?
There's no case law either way, no. And
And is it the case that staying for a portion of a critical stage in the case is permissible? Because that's essentially what you're arguing. He was there for some time, so that's okay.
Right, so you're saying, you know what, he gave them the basics, the foundations. Okay, so this is what's going to happen. They're going to ask you these questions. So here, I'm leaving now. You're on your own.
And as we get into the meat of things, I'm out, right?
Well, he
That's
stayed
okay?
for the meat of the discussion about this case. The topic had completely changed. And in this
But
case,
a
the
topic may
questions-
change. How do we know that the topic, because of what you're talking about, doesn't shift back to other things that might be incriminating, which in fact it did?
Which is what happened here, exactly when they
Yeah,
started
I
talking.
mean, again, under these facts, if we agreed with you, then that would mean that an assistant district attorney, they would never do such a thing, would then just shift the topic so that then the attorney would leave, and then once the attorney leaves, shift the topic back, and it would be fine.
So the
Right, and
question,
such a thing would never happen.
Never. I'm a former assistant district attorney, so I know it would never happen.
the question in an ineffective assistance case is not whether, looking back in hindsight, there might have been better representation. The question is whether, viewed the totality of the circumstances, the defendant received meaningful representation.
Right,
And
so
he was
that's
not
the issue.
missing
And
from-
so that was my question concerning the trial, because I asked whether or not information which came out during the proffer session when the attorney was not present, whether that information was used against the defendant at trial. And it was.
It was used against the defendant at trial only after he was again reminded before trial that if he testified inconsistently, then only, not in the direct case, but only as impeachment evidence, that case could, that
He was
information
acting,
could
he was
come out.
pro se at that time, right?
He had decided to be pro se at
Okay,
that time.
so
don't
you're
think he was
telling a
supposed to-
pro se defendant that if you open the door, you will, the information which was given during this proffer session where your attorney was not present can be used against you.
And he said that he understood that.
He understood that, and I'm sure he did understand that.
And-
Why would he not? Why would a pro se defendant not understand what opening the door means? And the fact that it could be used against him.
It's our feeling that if the defendant who chose and was specifically advised not to go pro se, it was not a good idea, and he decided to go pro se
He's right to
anyway,
do so. I mean, you can always advise a defendant not to go pro se.
he had the right to do so, but then when he did a poor job defending himself, that's not his previous counsel's fault, is the position of the
Well, what we can ascribe to his previous counsel is the lack of what he did, right? So if he's in a proffer session and conversations are occurring wherein he gives incriminating information about himself without counsel, that we can definitively ascribe to his counsel's effectiveness, right?
The people don't see it that way, but if they're.
And at the time that the defense attorney stated, well, you know, I don't want to stay because it may be a conflict with other clients that I have. Why at that point in time would the proffer session not simply end and another attorney, there'd be a request for another attorney or something of that nature to proceed, in order to proceed with the proffer session?
Well, that wasn't the only reason. It wasn't just conflicts with other clients. It was, as the record shows in the 440 proceeding, that he did not want to be called as a witness against his own client. But defendant was insistent that these proffer proceedings continue, and he in fact chose to go to multiple proffer agreement discussions with the DA after this one without his counsel. That was his decision.
But without a written waiver. No, wouldn't that have been
Didn't
an
inform
appropriate-
his, he
I'm
didn't
sorry?
inform his counsel about them.
Okay, but did anyone inform the defendant? You know, we're putting a large burden on the defendant to, you know, with knowledge of the procedures. Did anyone say to the defendant, you can waive having your attorney present? You can do a written waiver?
There's no information in the record as to what happened in that.
Thank you.
Thank you.
Counsel, is there information in the record about these other multiple proffer sessions?
The fact that there were other proffer sessions and that counsel facilitated these other uncounseled proffer sessions is in the record. So the idea that counsel didn't know they were happening is simply false. Counsel was interfacing with the DA to schedule.
Was he
them. This
present?
wasn't-
Was counsel present at the subsequent proffer session?
Not to my knowledge, no. And I think part of what your honors were getting at with the other questions of respondent for just a moment was that there should have been nothing to open the door to. Whether we decide we're going to want to put this burden on a pro se defendant to not only understand the law that apparently his counsel didn't understand about his right to counsel at these sessions, but we're going to have him know that anything he says there can be used against him, but only should he open the door. He shouldn't have made the admission in the first instance, among all the other things that are problematic about.
Well, he made the admission because that was part of the information he was imparting to the assistant district attorney, right?
Well, there was no reason for him to make the admission regarding the charged crimes at a proffer session that was largely supposed to be focused
So
on.
is there anything to be drawn from the fact that the judge here in the denial of the 440 kind of intimated that he did not consider, this was a bench trial, the defendant validly waived his right to a jury, right? So the judge intimates in the 440 decision that he in no way based his decision on this information that was brought in once the door was opened.
While I can appreciate the trial court sort of trying to minimize the prejudice that was clear on the face of the record after the fact.
But they're saying there was no prejudice because he didn't consider it.
Right. There was no limiting instruction given. The ADA was using this material both in his questioning and in his summation in a very substantive way. And if this were a jury trial, and I appreciate it's not, but if there was a jury trial, we wouldn't be sort of invading the jury's deliberations in the way that the trial court tried to do here in deciding the 440 motion. I mean, ultimately, as I started, there's no question that the right to counsel attached, and there's no question that counsel was not there. That's the end of the inquiry here, and this court should follow its really well-reasoned decision in Struthers, finding that even where counsel is absent for a portion, which is what was at issue at Struthers, a portion of a critical stage, that is the denial of the right to counsel, and this court should reverse the conviction and remand for a new trial.
Thank you. Kinsey v. Amazon.
Plaintiffs here.
Good afternoon, Your Honors, and may it please the Court, Gabriela Scarmato on behalf of Associate Funeral Services Corporation. With respect to the issues of the defendant's affirmative defenses for culpable conduct against the plaintiff, it is our position that there is sufficient evidence in the record that calls into question whether the plaintiff was operating the vehicle at a sufficient rate of speed, at a proper distance, and whether he observed what should have been seen.
What pieces of evidence reflect that specifically?
The evidence in the record is, one of them is Kinsey's statement to the police, where he stated that he was 2 car distances away from where the accident happened.
But he said 2 to 3.
2 to 3 car distances away from where the accident.
And so the vehicle is on the opposite side of the highway, flips over the median, and hits the vehicle in front of the plaintiff's vehicle.
Correct.
That's your client's car.
Correct, that flipped over, yes.
Your client's car flipped over.
Correct.
And hit Perez's car, I think is the one.
Correct.
Okay.
Correct.
And so how would there be any culpability on the part of the plaintiff where the car in front of him, wherein he states was trapped and he was behind 2 to 3 car lengths, is hit by this car that flips over the median?
Well, there's a question of fact because there is a witness statement of another individual who was about the same distance of where plaintiff was, who was
Kinda
able to
iffy on that
stop.
witness. He or she, I think it was he, really didn't see that much, right?
Correct, and that even goes to our point more. There was clouds of smoke that blocked this individual Navarro's vision, but he was still able to stop his vehicle, not make any contact with my client's vehicle that flipped over, and the vehicle in front of him was able to stop as well. So if 2 other vehicles on the road in the same position or similar position as the plaintiff was able to stop, that calls into question what was plaintiff
Were they in
doing.
the same lane, or wasn't he in another lane?
He was in another lane, but
Right.
2 to 3 car distances.
But in another lane, not in the same lane. I mean,
Correct.
these folks, these individuals, these vehicles were in the left lane.
Correct, but if the vehicle propelled, as plaintiff contends it did, and moved into other lanes, so much so that it forced him over to go into the trees, then it's safe to say that there was some movement that could have went into this witness's lane, but he was still able to stop at that distance so that there was no collision.
Are you resting at all on the police report, the
Yes.
statement that says that the plaintiff claimed to have been forced to swerve? Now, we don't know if he actually made that statement, correct?
We're not arguing that whether he was forced to swerve. I don't think there's any contention about that. It's whether when he did swerve, did he make contact with the accident vehicles, or did the accident vehicles propel him outward in the lane? So it's whether he had sufficient time to stop in order to make contact or not. That's our position. And at the time that the summary judgment motion was made here, it is our position that there was not enough evidence in the record that we should have been able to depose the plaintiff and conduct further investigation, which also leads to the police accident report and plaintiff's argument that it is inadmissible hearsay.
What I'm puzzled by is, even if he was too close, I don't see how that would have caused, how you could infer from that he caused the collision between your client's car and Mr. Procopio's car, which...
That's not the argument we're making. We're making that it is the plaintiff's negligence that caused his own injuries. Had he been more alert or not driving at a high rate of speed, he would have been able to stop his vehicle within time to not make contact with the other 2 vehicles.
Well, you're arguing that there are questions of fact that
Correct.
actually exist about that.
Correct. That should have warranted additional discovery, which should have
So
denied
what
this
additional
motion.
discovery would there be? Because unfortunately, the drivers of the two vehicles, your client and the car in front of the plaintiff's, Perez, they're both deceased.
Correct.
We have, I think, the passenger.
Correct.
And she was unconscious, and she
She was looking at her phone.
was looking at her
Correct.
phone, and then the next thing she wakes up or whatever.
Correct. So
After the accident, and then we have another vehicle in the right lane, I think, who really didn't see that much because of the smoke. So what additional
There was-
discovery would there be?
plaintiff's deposition was not held at the time that this motion was made.
But you already have an indication of what plaintiff's testimony is, right?
Well, there were statements made by the plaintiff in a contemporaneous statement with the police, but then there was also an affidavit submitted in support of this motion that had slightly differing versions of events in relation to whether he was propelled into this vehicle, whether he had sufficient time, that he made contact with the vehicle that warranted questioning during a deposition. In relation to the police report being an inadmissible hearsay, the CPLR allows hearsay arguments made in opposition to a summary judgment motion to raise questions of fact, which is what was done here. The police report, which plaintiff claims the box marking that whether the driver of my vehicle was unconscious or not, is inadmissible hearsay.
And we don't know where that information came from, right?
Correct. And at the time of this motion, we had not had an opportunity to subpoena the police officer to determine how he came to that conclusion, what time he arrived, whether he may have observed the driver moments before he perished to know that he was unconscious. We don't have those facts because at the timing of this motion, we were not able to do so. As it relates to whether proper medical records were provided to support the emergency doctrine, I rely on my papers to support the evidence that prior counsel to me had made efforts to obtain so-ordered subpoena to obtain medical records. The driver of my vehicle who had perished did not have an estate. There was no power of attorney, so we are making efforts to try to obtain those medical records, as well as obtain experts to opine as to whether the driver could have been unconscious and could have caused this accident because he was unconscious, which further warrants the dismissal of plaintiff's summary judgment motion based on prematurity. And lastly, as to the cross appeal, I will also rely on my papers, but note that it is not properly before this court. There was no summary judgment motion made at the trial court level and should not be considered at this time. Thank you.
Afternoon. May it please the court. My name is Leonard Romano. I am with the law office of Proyecto Beacon Elliott. Our clients are Almazan and Gonzalez in their capacity as co-administrators of the estate of the Perez vehicle. It is our position that not only is the associated vehicles fully liable, but because they're fully liable, that this...
You did not move for summary judgment against them below, did you?
We did not move for summary judgment. And on our position, cursorily, we asked the court to find summary judgment in our favor. So we did not actually use the exact words, search the record.
But that's what you're asking for.
That is what we're asking for, and that's what I'm asking of this court, to search the record, because the...
But even you would agree, although it's a very unfortunate accident, but if discovery, we really don't know what happened that caused Mr. Citron of the associated vehicle to have lost control and flipped. We don't know right now, correct?
Either way, we do...
Well, if it was an emergency situation, then there would be no negligence.
Either way, there's still no negligence on the part of my client, who had no time to react and sees a car flip suddenly and unexpectedly flip on top of him, killing him. And so there is no liability on my client. And that's why I've asked the court to search the record and at least dismiss this against my client.
Anything else?
No, if everything else, I will rely on the record.
Thank you.
Thank you.
People v. Mohammed Kotabi.
please the court? Sarah Siegel, Center for Appellate Litigation on behalf of Appellant Mohammed Katabi. This is a really upsetting case for many reasons. And we've raised 4 points.
Could you keep your voice up, please?
Yes, Your Honor. This is an incredibly upsetting case for multiple reasons, and we have raised 4 points of law in our briefing. I'd like to focus just on the first 2 for purposes of this argument. Beginning with point 2, the people charged the wrong version of rape in this case. There is no question at all, that approaching a sleeping woman and penetrating her just after she has awoken.
I'm not understanding you, I'm sorry. Could you speak up just a little bit? There's no question that...
There is no question that the conduct charged in this case was quite serious. There is no question that the conduct proven, according to the prosecution's testimony in this case, would constitute some version of rape under our law. The problem for the prosecution is it did not constitute rape 1 on a theory of physical helplessness.
Why not? She testified that she was in a state of sleep. She was asleep, in and out of sleep, when the defendant raped her.
Pointing Your Honor's attention to page 68 of the record. Question, in terms of your mental state and awareness while you were being penetrated, what was going on in your head, if anything? Answer, I was just thinking that, it's okay. Just get it over with and I can just keep sleeping.
Excuse me. She said she was asleep. She was in a state of sleepiness.
She says she's half asleep.
She's half asleep, she's half awake. She thinks it's her boyfriend who is penetrating her. So that's what she meant in terms of just getting it over. She thought that getting it over with. She thought that it was her boyfriend who was penetrating her. She did not know that it was a complete stranger, your client, who had come into the building, come into her apartment, and raped her.
Absolutely, Your Honor. And that would be... I really apologize.
You can adjust the microphone. You could pull it down further.
Yeah.
Thank you. That would constitute rape 2 under a theory of mental incapacitation. I'm looking at...
Are you challenging the physical helplessness element of rape 1? Is that
Yes.
the core of your issue, your legal issue?
It is.
And you don't seem, as my colleague pointed out, you don't seem to acknowledge that if someone is in this somewhat sleep, half-awake state as described by the victim's testimony, and plus other information where she afterwards realized she was being raped based on other information that we don't necessarily need to discuss right now, that's not an example of physical helplessness which was properly charged to the jury?
It is not physical helplessness, Your Honor. And I'd like
you read the part about, getting it over with. Although she said that she thought that she could get it over with and keep sleeping, she also testified that she very much felt like she was sleeping and was not in a clear state of mind. Otherwise, she would have noticed or turned around. Why is that not sufficient to constitute physically helpless?
Physical helplessness requires a complete physical inability to protest. We know that that does not cover mental incapacity because there's a whole other statute that covers mental incapacity. What the complainant describes here would absolutely constitute rape 2.
But why isn't sleep somewhere in the...
The issue
I mean, being in a state of sleep, it has elements of a mental incapacity and elements of a physical incapacity. I'm having trouble with the way you're trying to categorize it so narrowly.
The difference here is total sleep would absolutely be physical helplessness. In fact, we know that from the statute itself, which defines physical helplessness as either unconsciousness, not half unconsciousness, but unconsciousness, or being for any other reason completely physically unable to express unwillingness to proceed. Quote, so there are cases that say, even if you are paralyzed from the neck down, that is not physical helplessness because you have the ability vocally to say no. Similarly, all of the cases that the prosecution has cited here actually involve the loss of control over one's limbs.
What about Faye? What about that case? People v. Faye. The defendant
was asleep.
She testified, the victim testified that she was coming out of sleepiness and was confused, thought she was dreaming. and then she woke up to find the defendant performing a sexual act on her.
Right, the difference there is that she was completely asleep at the moment of penetration. Here, instead,
Wait, so you're going to state that under the statute, when penetration occurs, you have to be asleep?
yes.
Where does it say that?
For example, in Fay or the statute itself, which requires unconsciousness at the moment of
They specifically
intercourse.
stated that it was that physical helplessness had been established because she stated that she was sleeping in a state of sleep, coming out of sleepiness, and was confused.
It says nothing about having to be completely asleep during penetration.
We know that Fay is consistent with the statute and consistent with requiring penetration to be at the moment of unconsciousness because she's already been penetrated at the moment she wakes up. That's different from the case here. She says that she starts to wake up when she feels...
Starts to wake up, so she was asleep.
The statute, we require proof beyond a reasonable doubt of each element, not proof beyond a reasonable doubt of half of an element. I really want to focus on the difference here because the legislature has provided two options for the prosecution here. In fact, three options for the prosecution here. One is particularly when the defense makes a specific insufficiency challenge at the appropriate time on this basis, the prosecution should have said, okay, Judge, we'd like the lesser included of attempt because the only thing missing here is that she was completely asleep at the time. Everything else is present. Obviously, he came dangerously close to completing every single element of this. We'd like the lesser included of attempt rape 1 to be charged. That's option 1.
That's assuming that the definition means that the person has to be completely asleep, and
That
that's
is what the
not
statute
Faye
says.
says.
That's not only not what Faye says, but there are a number of cases which talk about this and which talk about the fact that you don't need complete unconsciousness.
The other cases all involve loss of control over the limbs.
People
Meaning,
v. Yontz, Y-O-N-T-Z, the third department case, victim who was still in and out of sleep was physically helpless. People v. Irving, second department case, again, physical helplessness is a question of fact, wherein the victim testified as to being in and out of consciousness. You do have time on rebuttal.
May it please the court. Good afternoon, Your Honors. Christian Rose for the people. I want to start with the statutory text because physical helplessness does not only require unconsciousness. It says the victim can be unconscious or for any other reason physically unable to communicate and unwillingness to act. Even assuming that physical helplessness required unconsciousness, at the moment that the penetration began, the victim said that at most she had started to experience the physical sensations of the defendant pulling her underwear aside and penetrating her. That would satisfy the defendant's definition. But even beyond that, the victim's state of sleep or semi-consciousness rendered her incapable of giving consent, and that's exactly what this court held in People v. Fay. And just a couple of points about why the victim's testimony here was credible. She was pregnant. She was 4 months pregnant. She was in a deep sleep. She had been suffering migraines from days, and I think anybody would understand how that sort of situation could lead somebody to experience physical sensations coming out of sleep, but not actually being able to process that information in any rational way that would be commensurate with consent. I believe that my friend on the other side mentioned that they were going to speak about antimarchy. I'm happy to answer questions about any other points, but I'll just briefly note that the defendant expressly waived his right to be present at the challenge sidebars 3 times, first at the beginning of jury selection, then right before the challenge sidebars, and then immediately after the challenge sidebars, the defendant himself said that it was all right that the sidebars had proceeded without him.
There's no requirement that this be in writing, is that correct?
No. No, and the waiver was perfectly valid. The court did not mislead defendant about his antimarchy rights. The note that the court made warning defendant that he would not be able to speak with people at the sidebars was clearly a reference that he would not be able to question the jurors. And we know that prospective jurors, and we know that the defendant understood this way because the initial sidebars occurred with defendant then interrupting the sidebars to tell his counsel that he no longer wanted to participate. So clearly he knew he could speak with his attorney.
Well, defendant asserts that the court's statement that you would not be able to speak with anyone, he took it to mean that he couldn't speak to, that was not limited to the potential jurors, that was limited to anyone.
Well, I think that's an unnatural reading for the reason that he's obviously speaking with his counsel. We know that he's also speaking with counsel about the anti-market rights 3 times before he actually waives his right to be present at these sidebars. Counsel is presumed to have informed his client correctly about anti-market rights, and we knew that he could speak during these sidebars because he did, in fact, speak to his attorney during the sidebars in order to tell him that he no longer wished to be present at these sidebars. Unless if your honors have any other questions, we'd rest on our briefs.
Thank you.
Thank you.
It's wrong that we know that my client spoke to counsel at sidebar. We don't know that my client spoke to counsel at sidebar. The only thing that we know is that the court told him he could not speak to anyone, that the prosecution's whole argument here rests on my client having heard from a judge specific words and said, I think the judge means something completely different. I think that when the court tells me I can't talk to anyone, the judge actually means I can speak to someone. The reason that
This statement by the court was made during the Antimarchian ruling, where the court spoke to the defendant concerning his being present at sidebars, and she stated that he could not speak with anyone at the sidebars. How would that translate to not being able to speak to anyone, period?
Well, the important part here for the right to counsel would be the ability to speak to counsel during the sidebar. The reason that that's the operative time period is under Sloan, it was my client's right and his fundamental right not only to make personal observations of the jurors, their demeanor, all of that.
Is there anything in the record would suggest that this was not done?
Yes, because
Where?
it was only after several sidebars, including decisions on those jurors, where the court said, now I'm going to give you an opportunity to speak to counsel.
Well, I thought that was after speaking with several jurors at the end of the first panel. The court stated, I just want the record to reflect that I'm going to give the attorney an opportunity to speak with defendant.
Right.
And
So that's-
defendant made it clear that it did not wish to participate in the sidebars anymore. Is that correct? And she checked it. So there was conversation back and forth with the judge and the defendant and his counsel.
But all after the judge had excused several jurors without any record saying like, oh, you can speak to your counsel about what you want to happen in these sidebar discussions.
Counsel consent to the excuse of those jurors?
I'm sorry, can you say
Did
that again?
counsel consent to those jurors being excused or object to the jurors being excused?
Under Antimarchy, it doesn't actually matter. Let me give you the citation.
It does, but thank you.
Your Honor,
And it does matter
there's a
in terms of
specific Court of
the
Appeals.
excusal of
So long as
jurors.
counsel either acquiesces or objects without having heard the Sloan observations, it is an Antimarchy violation. I can get you the citation.
I know Antimarchian, trust me. Thank you both. Sinclair v. Muhammad is submitted. Torres v. 40 East End Avenue Associates. Yes, please proceed.
Michael Prisco for the appellant. This court should reverse and grant summary judgment to the plaintiff on the Labor Law 241 claim because plaintiff was injured when a 675-pound pallet tipped and fell because the lift could not secure and control its descent.
Do we know why it fell?
Indisputably, yes. Plaintiff testified that the lift failed to secure the pallet because the coworker who was working with the hydraulic lift couldn't hold onto it, and he had to release it. It was error for the lower court.
Well, how do we know this?
Because if we look in the record at page 142.
Well, how do we know that this is the reason why this occurred? How do we know the reason why the coworker lost control of the pallet?
Because plaintiff was a firsthand witness with personal knowledge of the accident, and he testified at page 142, lines 2 to 8. Question, and then what happened once he was able to move the machine? Answer, the machine, he couldn't hold on to it. It just released, so he couldn't hold on to it. He had to release it, and that's why my foot got caught. And then on page 143 of the record, lines 2 to 7, he continues, counselor asked him, Question, no. I mean with respect to the hydraulic pallet. How did your foot get caught? Answer, he couldn't take control of it, so he had to let it go. And that's why it was error for the lower court to read intentionality into the record. The lower court dismissed the 240 claim because the lower court believed incorrectly that the coworker intentionally meant to lower down the pallet with the hydraulic lift when there's no admissible evidence to support that fact within the record. In fact, the defendants in their statement of material facts before the lower court, which is at the record 405 paragraph 16, they concede that exact point. In the statement of material facts, counsel for the defendant says, and I quote, "The driver operating the hydraulic lift machine lost control and released the pallet with materials onto plaintiff's right foot." On appeal, they abandon that concession and they point to an accident report, which is insufficient to either raise a question of fact or warrant dismissal of the 240 claim for two reasons. The incident report is at 233. The incident report is not authenticated, and under this court's and the Second Department's precedent, it is inadmissible and cannot be reviewed as part of this case. And even if it was authenticated and in admissible form, the report does not support a finding that the coworker intentionally lowered the pallet.
So in terms of the incident report, do we know who authored that report and whether he or she actually witnessed the event?
Yes, we do, Judge. It was Neil Rohbacher, as is on page 235. That's who signed it and authored the report. And Neil Rohbacher indisputably was not a witness to this accident. The only witnesses...
So he did not witness the accident?
He did not witness the accident, so that's number one. And number two, even if you took the language from the report, which in quote it says, "The worker who was pushing the pallet suddenly released the hydraulic level, dropping the full load of the pallet on Wilson's foot," that doesn't mean that that report doesn't say why the worker suddenly released the pallet. We only fill that evidentiary void through plaintiff's testimony, who had firsthand personal knowledge of why that happened, which was, as plaintiff said, that the coworker couldn't hold on to it. It just released. And there's evidence in the record they were having some difficulty getting this pallet out of the truck. At one point, before it fell, the pallet was stuck as they were trying to release it off of this truck.
So wherein perhaps defendants should not have been granted summary judgment, are there not still issues of fact as to exactly what occurred?
Absolutely not. There are no issues of fact because we know from, there's nothing in the record that is disputing the plaintiff's testimony. Again, a witness with firsthand personal knowledge. The only evidence we have in the record as to what happened was plaintiff's eyewitness testimony that as they were trying to remove this 675-pound pallet, the hydraulic lift could not secure or sustain or control the descent of the pallet.
So this goes back to my question, I think, earlier. Do we know why the pallet failed? Do we know whether it was defective or what the issue was in terms of the coworker not being able to manipulate the pallet with the
In this
load?
case, we're not making a claim that the pallet jack was defective, nor do we need to obtain summary judgment. Our position is that it proved inadequate under the facts of this case based upon plaintiff's testimony. I see my light is up. May I finish this one point?
Please.
And that's consistent with this court's precedent. For example, in Schoendorf, a 400-pound elevator platform was on a flatbed truck. The plaintiff lifted it 4 to 5 inches off of a pallet jack to put another pallet underneath. This court held that the statute applied because of the weight and size of the pallet, created a significant elevation differential, and this court said that the statute was violated because the pallet jack was a safety device that was insufficient to allow the plaintiff to move the platform off of the truck. So just under those circumstances, same here, the facts bear out that this hydraulic lift was inadequate for the work, and that is a violation of the statute.
Thank you.
Thank you.
Good afternoon. May it please the court, Courtney Chadwell, Barry McTiernan, and more for the respondents. So to the question of why the driver released the pallet jack, we don't know why. We don't know why the driver released it. I think the most reasonable interpretation of it, given plaintiff's testimony, is that after, you know, as they were getting it around the truck that it had been unloaded on, it gets stuck on the edge of the truck. And it's once they get it around that edge that then the driver accidentally hits the manual lever, the separate manual lever, that then lowers the pallet jack.
What information in the record do we have to substantiate that it was an accidental hitting of the lever that caused this versus a malfunction of the machine itself?
So we have, so plaintiff's testimony doesn't really point to a malfunction of the machine. And I'll note that, you know, obviously plaintiff is the spotter. He's not the one driving it. So plaintiff was just, he couldn't hold on to it. He had to release it. So that combined with the incident report, which is that it was worker error, I think that leads to the interpretation altogether from all of the circumstances that this was an accidental release of the lever.
So this is your motion for summary judgment, right?
Correct. We both had, we had
I'm
dual
sorry?
motion.
Yeah,
We had
your
dual
cross motion for summary judgment.
Yes, correct.
So are there no issues of fact as to exactly what occurred and whether the pallet jack was in fact defective and what caused the coworker to lose control of?
I don't think there are issues of fact, because while plaintiff is not required to point to a specific defect, he does at least have to show that the pallet jack was inadequate for some reason.
Well, in terms of it being inadequate, it didn't work. Like, it fell on him, right? So there is the inadequacy there. And a lot of what you're positing right now is assumptions about what potentially happened and inferences that we're supposed to draw, but no actual concrete evidence about it being an accidental release of the lever.
Right. I mean, I don't think that there's any evidence from which there can really be an inference that it was because it was defective, right? Because in the cases that are cited...
Well, we can infer because it fell that it was defective.
Right, but you know, the case law says that just because, I think it's Fabrizi, just because an accident occurs doesn't mean that 240 was violated. So in this case, there's no testimony that the load was oversized. There's no testimony that there had been prior issues with the lift, that maybe it was acting buggy or maybe there was something wrong with the lever. There's nothing in the record regarding that could lead to an inference that the pallet jack released because the lever failed.
Well, we're talking about the inference from the other perspective, but in terms of your burden for summary judgment, what do we have that's concrete and specific to sustain your burden for summary judgment?
Right. I think we have plaintiff's testimony and we have the incident report.
Do we have the
sorry,
coworker?
I'm sorry.
Go ahead.
What in I still don't see what in plaintiff's testimony supports your theory.
Yeah, I was asking, do we have the coworker? Because we only have plaintiff's testimony as to what he saw the coworker do or what he believed the coworker do. We don't have the testimony of the coworker.
That is correct.
So what in plaintiff's testimony would, again, sustain your burden?
If you can point us to a particular page, that would be helpful, because I just skimmed through it and didn't see anything.
Yes, so he discusses the circumstances under which the accident occurred at pages 138 through 142. And when he says why he couldn't release it, it's just he had to release it. That's it. So in combination, the only other concrete piece of evidence that we have that's why did he have to release it, it's basically that it was worker error and it was accidental. It was
Well,
not.
I mean,
it was worker error. It wasn't because there was something defective.
We're really not sure about that, are we? I mean, I think there's a lot of issues of fact. I mean, there is some indication that it's worker's error, but that does not seem to be the definitive situation, and there seems to be testimony here that there may have been something wrong with the actual pallet jack, which caused it not to be appropriate for the work that it was supposed to be doing.
I mean, it does state that the hydraulic machine was full of very heavy merchandise. He says that the machine got stuck because the wooden part of the pallet was attached to the hydraulic machine broke. He says that the driver could not get it out at first, but then he was able to unstick the machine that was stuck with the pallet. So that could mean that the pallet was somehow defective. We don't know. He also says that when the truck driver moved the machine, he couldn't hold on to it. It just released. So he couldn't hold on to it. He had to release it, and that's when my foot got caught. Again, these are statements by the plaintiff as to what he believed occurred. that he believes that the coworker couldn't take control of it and just let it go.
I will say, I know that my time is up, but I'd just like to point you to page 287 in the record. That's when one of the respondents indicated that the hydraulic lever on the pallet jack that was involved in the accident was not defective and did not fail in any way.
Well, that was Rohrabacher? I think it was Rohrabacher, Rohrabacher, said that he had no idea why the it's either Rohrabacher or Sullivan had no idea why the coworker released it.
Right, and then he also testified that, to his knowledge, there was nothing defective
Well,
or.
I think he said was, I don't have any reason to believe.
Correct, Your Honor.
Right.
I don't have any reason to believe is not an unequivocal statement that all
Right.
is right as roses.
I wouldn't hang summary judgment on that.
But thank you. Yes.
Defendant's citation in the record to that testimony of Mr. Roebuck, he was not a firsthand witness, and he does not unequivocally say what happened or what did not happen. What we have here in the record is
So counsel, essentially, while you were seeking summary judgment and feel it was error not to get summary judgment on 241, at the very least, you would recognize that there is a possibility of issues of fact. So the ballgame isn't over yet if we go that route, right?
Yeah, the worst case scenario, there's a question of fact on 240, but I believe here where you have plaintiff who has personal knowledge of what went wrong, the pallet was broken. We see that in the record, that the pallet broke as it was getting off the truck. The testimony that there was 675.
If it was the coworker's fault, if it was coworker error, as it says in the incident report, although I'm not sure where they got that from, would that mean that it was not there was not summary judgment, still leave issues of fact?
That would not be a 240 case. I would agree with the trial court if that was the case, but that's not what happened here. And on page 234, that's where it says worker error, but that's Neil Rohrabacher who says that he's not a firsthand witness. No one has ever said it was worker error. And if you look at plaintiff's testimony, he's unequivocal. He doesn't say, I think, I believe. He definitively is saying, when asked what happened, he couldn't hold on to it. The worker couldn't hold on to it, this 675-pound pallet, and he had to release it. And if you look at a case, it's a second department case, but it's squarely on.
So it was what you're saying, so that means that the pallet was just not appropriate for the work that it was supposed to be doing, carrying this very large load.
Yes, and you prove a violation by showing a defect in the safety device or that the safety device was inadequate for the work. And we've proved the violation here because the safety device was proven inadequate for the work. If you look at a case we cite, Ramos-Perez, it's a second department case, 168 AD 3D 1112. There, plaintiff and a coworker are trying to get a pallet off of the back of a truck. They're using a lift. The top of the truck to the ground's 4 feet. May I finish this point, Judge?
Yes.
Is 4 feet. When they bringing this down, it falls, it strikes plaintiff. Summary judgment was granted because the facts established defendants violated the statute by failing to provide an appropriate safety device to secure the subject materials as they were being lowered.
Thank you. Thank you both. People v. Angel Nieves. Yes, you may proceed.
Good afternoon, Your Honors, and may it please the court, Rachel Pecker of the Legal Aid Society on behalf of Angel Nieves. This case depended solely on witness credibility and no other evidence, and in the prosecution's eagerness to get a conviction, the prosecution muddled the waters at every stage of these trials. First, Your Honors, the court's amendment of the timeframe in the indictment was unreasonable. The prosecution asked for a 21-month extension, changing the timeframe from 2 years to over 4 years. Respondent nor
for
I.
that after the proof, right? And it's permissible to amend the indictment to conform to the proof at trial, right?
if you're asking whether it's untimely, it wasn't untimely, though it goes to a prejudice analysis. But the extent of the amendment was what was unreasonable here, Your Honor. Respondent nor I can find a case where a court has ever upheld an extension this long. In cases where amendments are granted, there is ongoing, daily, regular, multiple incidents, and that didn't happen here. In fact, the cases that respondent cites for child complainant cases where, based on the proof at trial, an amendment was necessary, the court granted 2-month extensions to several months, and several months was with 11 incidents. But here what we have is we have only allegations of 2 incidents that happen on one day.
You also have a 6-year-old, right?
Exactly, Your Honor. We have a 6-year-old. So 2 incidents that happen with a 6-year-old on one day. And then under the prosecution's amended theory, we have one other allegation that could have taken place 4 years ago when she was 2 years old. That is simply too remote. What we know about the prosecution's theory, Your Honor, is that originally they thought these acts took place within 3 months of each other. But when the prosecution goes to dismiss the first and second count after the end of the first trial, she says, my proof didn't prove, as we thought it would, that these took place in a 3-month time period. So they go from 3 months to 4 years, the entire time that they lived together, which shows that the extension just simply was not in good faith. It cannot be.
While there was an extension of time, was there any change in terms of the incidents? Wasn't there just 2 incidents involved during that period of time?
No, Your Honor, there was 2 incidents on one day when the complainant was 6 years old, and then the other, at the first trial, the other oral sex act was then could have happened any time period within 4 years.
But it was withdrawn. I mean,
Right.
the people conceded that they couldn't prove it.
No, they couldn't concede the first 2 counts, which was the predatory sex act and the course of conduct
Which was
sex
part
act.
of which was the act that ultimately became the subject of the Molyneux ruling, correct?
Correct. So at the first trial, though, it is relevant to the
We're
endangering,
only
the last
talking
count.
about we are only talking about the reckless endangerment.
The endangering the welfare at the first trial.
Endangering the welfare, right.
Yes, Your Honor. Yes.
So in that expansion, again, that was to conform with the testimony. What was the testimony?
The testimony they thought was going to be that she was in kindergarten or pre-kindergarten, and then it turned out she didn't remember at all, that she just remembered that they lived together. My point is simply that even when there's a child complainant, it cannot be that there are no guardrails. It cannot be that it can extend by this amount of time.
What's the
And defense-
prejudice? What are you arguing as the exact prejudice?
Sure, Your Honor. Once the prosecution had amended the time frame to include the entire time they lived together, the defense didn't have an opportunity to impeach the complainant on that or call the
But
prosecution.
the incidents didn't change within that time frame, right?
Right, but what the defense could have called other witnesses, such as the numerous roommates, including male roommates that they lived with during those 2 years, or put forth other evidence. We don't know. Once the judge...
But the incidents itself that was already known to defendant didn't change, so you could have called those witnesses regardless of whether that time...
With respect, it would have been different witnesses, Your Honor. There was a 2-year time frame that this defense attorney didn't have an opportunity to investigate.
After the court's ruling, were you precluded from requesting of the court to question the victim, the complainant, regarding these incidents?
Precluded, no, Your Honor. But once the court made its ruling, the defense was put in between a rock and a hard place. The amendment...
But that rock and hard place, between that rock and the hard place, you could have asked to question the complainant concerning this expanded time. And you could have also brought in you could have asked for a continuance also in order to bring in witnesses.
Once the court made the amendment, the defense had a choice to recall, that's what I think you're asking, recall the complaining witness. But child complaining cases are extremely delicate for all parties. If he had recalled her, he would have risked the jury hating him. He would have recalled the complainant, put her on the stand, and subjected a 6-year-old witness to more cross-examination. He was damned if he did and damned he didn't. He made the choice not to recall, but he did object to the expansion.
Counsel, I'm sorry. Notwithstanding the expansion of the time frame, the focus of the second trial was the January 2018 incidents of fondling in one day.
Correct, Your Honor.
That was the focus of the sexual abuse charges, correct?
Of the second trial, yes, Your Honor.
And putting aside the Molyneux ruling, there was nothing about the prior 2-year period or 3-year period that was implicated at all on the January 2018 charge, correct?
Right,
So where's the prejudice? I don't
well, the amended
understand it.
time frame just goes to the first trial, and we do believe there's prejudice for the reasons that we said. But going to the second trial, we believe that the erroneous Molyneux ruling, once the vaginal touchings were the only acts charged, the Oral Sex Act never should have been before the jury.
Thank you.
Thank you.
Good afternoon. May it please the court. Stephen Kress on behalf of the people.
So let's,
Could you address the Molyneux rulings and why those weren't unfairly prejudicial?
Yes. So, do you want me to speak to propensity or just the second prong of the analysis? Just the
Well, first speak to what was your non-propensity reason for putting forward.
I mean, I don't. Your argument was that it completed the narrative. It showed the jury. It would inform the jury as to why the defendant felt emboldened to do this because apparently he had done it previously.
So there were two reasons. One is, yes, that I think it would help to explain conduct that would otherwise seem inexplicable. And this is...
Well, you had an expert, right?
We did. And actually, that expert said that it was unusual. It very rarely happened for somebody to ever molest a child in somebody else's presence. And that's what we had happen here when the defendant was touching this 6-year-old girl on the bed in her own mother's presence, not just with anybody there, but with her own mother.
Who was also on the bed, right? Wasn't she on the bed as well?
That's correct. She was also there. And so I think, as we said, a jury could look at that and find that very peculiar. And that's what the Court of Appeals in People v. Brewer was talking about. And so this testimony...
Let's talk about Leonard. How is this different from People v. Leonard?
It's different in a few ways. One, it was I think, identical conduct in Leonard, with like the Molyneux evidence and the actual charged crime was virtually identical. Whereas here we have different conduct being charged. The second reason is that there was no limiting instruction given in Leonard.
There's nothing in Leonard which states that the basis for the ultimate decision was because there was no limiting or curative instruction.
I mean, they absolutely point out that there was no limiting instruction there.
But it doesn't. They do not state that if there had been, then the decision would have been different.
No, I agree with you. I don't think that that's necessarily the linchpin, but I do think that's something that makes this case different than Leonard, and that we did have a limiting.
How is this not prejudicial? Again, you know, your friend was talking about where you have child victim cases. They're very, very difficult in terms of presenting them to the jury, in terms of how the jury is going to view these cases, et cetera. How, under these circumstances, would that not be prejudicial?
Well,
for this child to testify as to this act performed by the act between her and the defendant, how would that not be prejudicial to the jury?
Well, so I think we're talking about it's. I mean, yes, it's powerful evidence, but
that's a wrong P word. It's prejudicial.
It's prejudicial. I mean, once the jury hears about this prior incident, oral sex, right? Prior incident between this child and the defendant, why would they not immediately think, oh my gosh, he is guilty of these charges?
Right. Propensity, that's another P word, right?
The first trial. This evidence was presented at the first trial, and there were the jury hung on the 2 sexual assault charges. They weren't
the Molyneux? No, the Molyneux was only the second trial.
It was presented as Molyneux evidence at the second trial,
exactly.
but the oral sexual conduct was part of the charged crimes in the first trial. The jury heard that evidence, and they did not say, they were not so inflamed that they said, oh, we've got to just put this guy away for whatever he's charged with. They hung on the first 2 counts.
But that was a charged crime. It's different where you're talking about a charged crime and you're talking about a Molyneux determination. Totally different. It's an uncharged crime.
But I think the point is that if you're concerned that this evidence was so prejudicial and inflammatory that it's just going to lead the jury to convict him on anything, well, I think the first trial disproves that.
So because the first jury didn't convict him because that was a direct charge, that the second jury was not prejudiced by hearing about this outside incident? Is that your argument?
I think that the fact...
So we're basing what would prejudice one jury on what another jury was not able to convict on?
I think the fact that the first jury heard this same testimony,
So it couldn't have been prejudicial because that first jury didn't convict him, right?
I think it undercuts the argument that this was so unfairly prejudicial that the jury would have been so inflamed that they would just throw caution to the wind and convict him of anything.
You also overlooked that they didn't have a time frame for when that occurred in the first trial, which resulted in the people asking that those charges be withdrawn. And of course, the jury probably got an instruction, because I don't have the record of the first trial, to disregard all that information. Would you agree with that?
I don't think they were told to disregard the evidence of the oral sexual conduct at the first trial. That was still part of the charged crimes in that case, and I think they ended up convicting on the endangering charge.
Any cases that you can cite wherein, for that proposition, that where you have one jury who considered it, didn't find it prejudicial, or did not find those charges, so therefore it wasn't prejudicial?
I can't think of one off the top of my head, Your Honor.
Is that the definition of what would constitute something that is prejudicial, true prejudicial, on the Molyneux?
It's a factor that I think the court should consider in the analysis, and I think that
It's not a factor listed in any case on Molyneux from any time, right?
I'm not prepared to concede that, actually. No, Your Honor. But I think...
But if it was, I'm sure you would have found the case, right? Because it supports your argument.
I would hope so, but I'm not going to say that one doesn't exist anywhere in the case law.
Thank you.
We agree with Your Honors that I think that it was extraordinarily prejudicial. Not only was there not a Molyneux exception, but there was no probative value, and even if
there was, I mean, I recognize that you base part of your argument on Leonard. The people attempt to distinguish it. It is clear that in this case there was a curative instruction given to the jury concerning how they should or should not consider the testimony concerning the oral sex.
Yes, Your Honor, and for reasons that I think you already alluded to, not only is it not, does it say that will always solve the problem in limiting instruction, but a limiting instruction could not unring the bell here.
Anything to say about the limiting instructions given here?
Sorry, what about?
Anything to say about the limiting instructions given here?
There was a limiting instruction given here.
Were they adequate?
No, it wasn't adequate. Once the jury heard this grotesque, more disturbing, more graphic Oral Sex Act testimony at the second trial, they couldn't unhear it. The prosecution in summation described the jury gasping when she testified to this, and then the prosecutor repeated all of the young girl's testimony.
The instructions themselves, did they go to the issue of prejudicial versus non-prejudicial, and not considering for the purposes that the defendant is now guilty of these charges? The substance of the curative.
I don't believe they addressed prejudice, they addressed propensity. You may not, the standard charge, you may not consider it as proof, but of course we know that that's what they do. And I would just say one other thing, Your Honors. I do think you can't look at point 2 without looking at point 3. If for any reason this court were to hold that the Oral Sex Act did meet the Molyneux exception, which I don't think it does, and I thought the prejudice extraordinarily outweighed any probative value, I would just say that there is no way to uphold the denial of the 330-30 motion to set aside the verdict, because without the newly discovered evidence, the jury only got to hear one explanation of what the court below and now the court here would be saying was critical to the case.
Thank you.
Thank you, Your Honors.
Cummings v. the City of New York. Yes.
Good afternoon, Your Honors. Justin Ames, Aiken Law Group, on behalf of the appellant Kavarda Cummings. This court only needs to answer 2 questions to reverse the lower court. The first question is it reasonable to infer that a supervisor's baseless accusation that a female subordinate had sex with a different male supervisor in exchange for professional accolades, is that gender-based? The second question is it reasonable to infer that the supervisor's mistreatment of the female subordinate immediately following his accusation was motivated at least in part by discriminatory animus? And the answer to both of those questions is unequivocally yes. There is plenty of case law that establishes that under the New York City human rights law, even a single comment of gender animus is sufficient to create a hostile work environment. That's Goldstein Green v. the City of New York out of the Second Department. That's Williams. That's also Hernandez v. Caseman. The situation here is very clear. The supervisor accused Ms. Cummings baselessly of sleeping with the higher supervisor for a perfect score on her performance evaluation. That is indisputably gender-motivated and gender-based conduct, because that specifically speaks to all sorts of historical views about women in the workplace and whether...
And this is actually just a 30-11 motion, right? This is so on the pleadings, we are supposed to, it's sort of a notice pleading standard, and I don't think anybody disagrees. I don't think the judge in Supreme Court disagreed either. It's just he stated the case. He actually said that at the beginning, but then he found that what you alleged was not sufficient. But it seems that under the standard that we use, it at least stated a cause of action.
Yes, Your Honor, that would be our position, especially under VIG. It's very clear that there's a notice pleading standard that but the court's decision, the lower court's decision, said that there was essentially no discriminatory animus and no connection between the gender or sex and the allegations, but that single comment by itself is sufficient to create a discriminatory hostile work environment and discrimination under both the state human rights laws amended after 2019.
So I want to ask you another question that got me a little confused. The judge made a mention of the claims for aiding and abetting this behavior. And I looked at the First Amendment complaint, which is the operative complaint in here, and there's no cause of action for aiding and abetting discriminatory conduct. You did make some allegations in your First Amendment complaint as to where there may have been some aiding and abetting conduct, but there weren't causes of action there, right?
Well, Your Honor, there actually were.
I mean, they're not. Well, they're not. Actually, they weren't, because I looked at the complaint. And
Your Honor, I'll explain where they are located. It is, first of all, it's a legal aiding and abetting is a legal theory, not a separate.
It's a legal theory, right? That's what I'm saying. So it's not a cause of action.
Right, but it is also inherently included in the causes of action, because you'll see under the parentheses when it says first cause of action.
Counsel, I have the complaint. Where is it? Where is it you're referring to?
In the First Amendment, under each cause of action, the First Amendment complaint, it says as to all defendants. So that is, and there are allegations contained within the text of the First Amendment.
Right. On 172, paragraphs 172 and 173 of the complaint, I see your allegations about that. So for some reason, the judge felt that it included one sentence where he said, those causes of action, although I don't think I would call them causes of action, were dismissed because you didn't adequately state the other cause, the actual discrimination. But if in fact we were to say, okay, you made out, at least you stated a cause of action for discrimination and hostile work environment, then you could include these claims, whether you prove them or not, that's different, but they could be part of your case, right?
Yes, Your Honor, that's our position, yes.
So in particular, the trial court said, to the extent that plaintiff alleged a cause of action for aiding and abetting discriminatory conduct, such a cause of action is dismissed. But as far as I could see, and I agree with Justice Kapnick, that there doesn't seem to be a cause of action specifically about aiding and abetting. Is that right?
That's correct. It's not a cause of action. It's not a discrete cause of action for aiding and abetting.
It's like an allegation.
Correct. Whether or not the individuals are liable under an aiding and abetting theory under each of the discrete causes of action.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Hannah Sorokin for respondents. Your Honors, unquestionably, the comment as alleged here was uncivil. But as this court has long held, the human rights laws aren't a general civility code. And what plaintiff here needed to allege was that under the state human rights law, some material adverse.
We're not talking about civility in the general sense or somebody being rude. It's specifically her immediate supervisor claiming that she slept her way to a favorable employment a review. I'm sorry. So it seems to me that's not a question of civility. That's a question of treatment on the job, and that's how we get to discrimination. So I don't understand why you think civility is the right standard. It seems to me we're looking at a claim under the employment laws based on conduct that occurred during employment.
I think in this situation, the comment that was made, in our view, is not inherently gender-based. It's a comment certainly about.
I'm sorry, the argument that a woman slept her way to the top is not gender-based? I'm having trouble understanding your theory why that's not about gender.
Well, I think under both the state and city human rights laws, there has to be an allegation that leads to an inference that the complained of conduct was based on animus, in this case towards discriminatory animus on the basis of gender. And when we look at the complaint as a whole here, we don't see that. And the comment in isolation, and certainly discuss it in the context of the entire complaint, but the comment in isolation is not a comment that would only be made about women employees. It's a comment that could be made.
It's the historical context of that
Exactly.
comment.
I mean, my question was, don't we look beyond that and note the fact that it's normally, or historically, it's been an allegation that women are the ones who sleep their way to the top, quote unquote, to the top, wherein men don't do that because they're already at the top, right? But I mean, historically, so we have to look at the circumstances, the overall circumstances. The comment made was, when you sleep your way to the top, I don't knock the game, I don't blame you, you got to use what you got. Which again, context, historical context, seems to be referring to her gender as a female.
And also suggests that she doesn't have the actual skills to do the job.
Exactly.
Well, I think here, looking at the complaint as a whole, what the plaintiff here alleges is that this all actually arises from an interpersonal conflict with the supervisor. There was very early on, it seems, a miscommunication about
her scheduling,
her scheduling, and that led to clearly a conflict.
Well, that was the whole issue, because the reason allegedly he makes these statements is because he did not believe that she should have gotten a perfect rating. She got a high rating on her evaluation, and apparently he did not think that she deserved that rating, and that's why he made the statement that the only reason she got that rating was because, again, she slept her way to the top.
The miscommunication about the scheduling became before that, the evaluation, which was with a different supervisor, not the one.
She already had the positive evaluations at that point.
The meeting about it had not happened, and
But she had already received the positive evaluations.
Right, that's her allegation, is she had already received the highest evaluation, and it was after this that the statement was made to her by Cleckley.
I believe, if I'm recalling correctly, the order of events was that I think the evaluation occurred with the prior supervisor who'd been her supervisor for 2 months, but she did not have the meeting about it until after she'd already begun working with Cleckley. But he was not involved in any way with the evaluation. Right. But he was in that meeting. But her conflict with Cleckley about scheduling, I believe that occurred prior to the evaluation.
Right, but what does that matter? Like, what's the legal import of what you're saying, the fact that this happened before the statement?
I think we would submit that looking at the complaint as a whole, it doesn't allege or give rise to an inference of gender-based discriminatory animus. It gives.
So, just so that I'm sure I'm following you, are you saying that because she had this previous disagreement about schedule and the fact that this comment was made after that disagreement, that there's not enough here to meet the standard to state a claim?
Our position would be that the complaint read as a whole indicates an interpersonal conflict, which the human rights laws are not intended to address. And there's also no allegation.
And it's interpersonal conflict just based on this one issue regarding the schedule?
There are other allegations throughout it. For instance, she alleges that there was an incident with truck keys, and that Cleckley thought she'd taken his truck keys, and then it turns out that it was another employee who had done that on accident. That other employee was a woman, and so I think the complaint here does not allege gender-based animus.
So don't look at the statement that was made to her about sleeping her way to the top.
Well, it's in the context of the complaint as a whole, that the basis if there was of any alleged misconduct. And I'll also note she doesn't allege under either the state or city human rights law an adverse or unfavorable or disparate treatment. She doesn't allege that she was treated differently than, for example, her male coworkers, such has been in.
I'm sorry.
Go ahead.
Wasn't there allegations about him being angry at her for actually filing a complaint with his supervisor, and then he proceeded to make her life miserable to create the hostile work environment directly related to that complaint?
I will just note that her retaliation claim, we did not move below to dismiss on that basis. There is a retaliation claim still active below. But I think the specific allegations that she makes, and this court has held that, especially when discussing differential treatment, has to be, even at the motion to dismiss stage, it has to be a specific, I believe, a specific and factual allegations. That's in the Serrano case.
Thank you.
Your Honors, just specifically with respect to the issue with scheduling, first of all, the scheduling incident was Watson, who was the supervisor that Ms. Cummings was accused by Cleckley of sleeping with, fixing a problem that Cleckley caused by this scheduling. The complaint is a speaking complaint, and it basically says that's where we believe he formed this belief that she was receiving preferential treatment, which he believed baselessly was in exchange for sexual favors. All of the conduct, then the meeting happens with the 20 out of 20 performance review, and then all of the conduct following that allegation where he says you're sleeping your way to the top is motivated by that animus, that discriminatory animus that you must have received this perfect review and you must have received this the prior treatment, the prior scheduling, payment for a missed day, I think, because you're in some sort of sexual relationship with Watson, the higher supervisor. I just want to briefly speak about material adversity. Material adversity is not a requirement under the city human rights law. That's never been the case. And under the state human rights law, there is no basis to believe that material adversity is an element since the 2019 amendments to the state human rights law. That is even further reinforced by the United States Supreme Court's decision with respect to Title VII in Muldrew v. the City of St. Louis, where Justice Kagan, in her opinion, said materiality is not a component of an adverse employment action. The state human rights law in New York Executive Law Section 300 specifically says that even if there are terms under the federal and the state law that are the same, the terms in the state law is to be interpreted more liberally and more broadly than the federal law. So you would have a situation if you imported a materiality requirement to the state human rights law where the state human rights law is less broad and less liberal and less protective than Title VII, and that contravenes especially the 2019 amendments to the state human rights law.
Thank you.
Thank you.
AG1 Joe V. Morris. Yes.
Your Honor, good afternoon. May it please the court, I'm David Ross of Kasowitz LLP. I'm here with my partner, Sandra Grigsby. We represent George Morris, the appellant defendant in this case. Before I begin, I just want to note, Mr. Morris vehemently denies that he attacked the plaintiff 42 years ago, or 42 years earlier than 2020 when the complaint was filed in this case. That's what we're talking
Here on a
about
motion to
is
dismiss, we're not getting to the merits. We're-
no, I simply want to note because we're talking about
Counsel,
due
let's stick to
process
the
of a
legal issues
defend-
in front of us. Let's stick to the legal issue in
Yes,
front of us.
so I'm here to talk about the constitutionality or lack thereof of the Child Victims Act, which in this particular case, our challenge is both facial and as applied.
So what about the Forbes case from the Second Department, which came out a couple years ago, and I know has been cited a lot, although in looking at the papers, I am aware of the fact that this your motion, original motion, was made quite a number of years ago. I don't know what happened to it, but it was only decided more recently. But still, now that we're here now, hasn't everybody pretty much found that this Forbes is pretty much what everybody's basing their decisions on in terms of the constitutionality?
Both Forbes and in the Third and Fourth Circuits, they have said that the CVA is constitutional. This court has never addressed the question yet. I'd like to explain why I think that they are wrong.
So why would we not be bound by the determinations made by a co-equal department?
To my knowledge, Your Honor, you're not at all bound by what they have done. The Court of Appeals sets the stage for this court.
But
in
even
terms
why
of-
wouldn't we?
Why wouldn't we follow it?
Why wouldn't we follow
okay,
it since it's been established?
allow me to explain. Under the Child Victims Act, they have revived without limitation all claims that ever could have been brought that meet the statutory standard without any limitation whatsoever. There is no time limit whatsoever going backwards in time during the statutory window that they opened. Second, that is unique. That is unique in the
Similar
law.
statutes have been adopted in many, many states and have always been found constitutional as well, right?
24 states have rejected claim revival statutes just like this one.
And I know, Counsel, we mentioned the Court of Appeals and the fact that the Court of Appeals has not specifically dealt with this issue, but the Court of Appeals has dealt with claim revival statutes and has stated that a claim revival statute satisfies the due process clause of the state constitution if it was enacted as a reasonable response in order to remedy an injustice. And that is the basis for Forbes, and that is the basis for other decisions.
You're correct, Your Honor. In our brief, we lay out that the unique circumstances of the 4 other cases over the last 100 years where claim revival was permitted involve situations where the plaintiff could not have brought their claim. They didn't know about it before the statute had expired. A war occurred. There was a Supreme Court decision which invalidated their ability to bring their claim. This is the only case where people who have known about their injury had complete knowledge of their injury.
When you say this is the only
our case.
When you say this is the only case, you're talking about cases arising under the CVA. Is that correct?
Yeah, and let me just turn to, so there's something very unique about the CVA that doesn't match up with any of the prior statutes that the Court of Appeals has endorsed. And in Zupano in 2006, the Court of Appeals specifically talked about the scourge of child sexual assault cases and turned out of court the children who brought claims in 2006 saying they were aware that the priests molested them. They had notice of their claim.
So that was prior
they didn't
that
timely
was prior
file it.
to the enactment of the CVA.
Yes.
Plaintiffs had argued that the doctrine of equitable estoppel should allow their time-barred claims of childhood sexual abuse to proceed. The issue was the applicability of the doctrine of equitable estoppel.
I agree with you, Your Honor, but the point stands.
But that's not
the Court of
relevant. My
Appeals
point is, I'm sorry, I
previously-
should have continued. That's not relevant to the constitutionality of the legislature's enactment of the CVA.
Your Honor, let me
which
just
is the
talk
issue here.
briefly, if I may, about the as-applied challenge, because here our plaintiff in this case says he knew about his claim. He was according to him, 17 years old and 10 months, 17 years, 10 months old. He said he knew about his claim for his whole life. He didn't sue because he didn't want to hurt his employment opportunities in the equestrian world. He chose for 42 years not to sue my client or give any notice. He no opportunity on a due process basis, on a fairness basis, on an evidence gathering basis. 42 years later, someone knocks on the door and said, "You hurt me 42 years ago at an unnamed place."
Most of those 42 years, excuse me, for most of those 42 years, he was barred by the statute of limitations from suing.
During all the time that he could have, he didn't bring it.
Right, when he was 17 and 18,
He said
which is a
that-
very different thing in terms of an ability to pursue a piece of litigation. Perhaps you're not familiar with all of the psychological literature
Of
that
course,
was reviewed by the legislature before
course I-
passing the CVA.
That was the reason for the CVA. That's the purpose, the legislative history. The reason for the CVA was because of that. These claims were time barred.
Agreed, but no, the Court of Appeals has never said it's okay. I mean, they generally, in the Regina case and other cases, have said we have to be very careful about claim revival because
Regina's
it
a-
upsets the
Regina's a
expert.
question of
Regina on
rental
rent
disputes.
regulation is very, Regina on rent regulation is very different. than-
I think rent regulations and whether or not you have been sexually abused as a child are totally different things. I think they're apples and oranges.
Well-
As I said, the Court of Appeals has stated that a claim revival statute such as this will satisfy the due process clause of the state constitution if enacted as a reasonable response in order to remedy an injustice.
I agree.
The legislature determined that the inability of these individuals to bring these suits is something that has to be remedied, and it is an injustice. But you have time on rebuttal.
Thank you.
Thank you.
May it please the court. Sagar Shah for the plaintiff respondent. I think this court recognizes very clearly what satisfies the due process clause, and it's that the statute was enacted as a reasonable response in order to remedy an injustice.
So two issues on appeal. One issue is whether or not it violates the Constitution, whether it violates the Constitution, right? The other issue was whether or not there's a stated cause of action for negligence.
Yes, Your Honor. So there are three causes of action in the complaint. One was for the sexual assault, one is for negligence, and one was for negligent hiring by the corporate entities who were not.
Right.
And so the negligence cause, here, I think it's pled in the alternative. I think the argument.
But it doesn't work, though. You can't have an intentional assault and have negligence. They don't work.
I understand. I think, you know, the negligence causes of action are really against the corporate entities here. It's not as against.
Really against the corporation, not necessarily should be sustained against your individual, I mean, their
the
individual client.
Yes, Your Honor.
And did you want to add anything as to the constitutionality issue of the CVA?
I think the court, I think the justices have spoken on that. I think there's nothing more I have to add on that.
Thank you.
Thank you.
I want to just talk about what is actually pled in the complaint, because I think it's striking from a due process standpoint with respect to my client under these facts. The plaintiff pleads that on some unstated date at an unnamed motel.
When he was 16, when he began to train, he states that in paragraph 3. I'm sorry, in a hotel, he states it was the spring of 1978.
When no witnesses present.
That's not uncommon
you
with
know,
regards to
it's
sexual allegations, is
right.
it, counsel?
I understand, but from a defendant standpoint, in terms of trying to defend yourself, if I accused anyone
Most defendants
of having done something 42 years ago, and you had no ability to gather evidence, interview witnesses, have your alibi, say that you were 10 miles away, tried to plan your case, plan your defense. The reason why we have statutes of limitations is to compel, particularly in intentional torts. You have to bring it on within a year. This is a battery case. It's an assault case. How are you supposed to gather evidence now, 42 years after the fact, and defend
I mean,
yourself?
look, I have heard this argument many times, and I don't think we're unaware of the problems that it presents to the defendants that have to defend these cases. But the plaintiffs have to make out the proofs, and a jury has to believe it. And there's been a lot of discovery that's gone on in these cases, and I think it's unlikely that the first department is going to go against all the other departments on this case. There have been so many of these CBA cases, as you know, already. It's been going on for years. So I think we're cognizant of it, but we're also cognizant of the amount of evidence and investigation and time that the legislature took to,
Justice Kapnick, that's why I also have asserted in the alternative that as applied under only the facts of this case, with the unique pleading that this plaintiff purposely chose not to sue for his employment benefits. He wanted to have his opportunity.
I will state that this is not unique. We've seen these cases. There are numerous cases where this has occurred, where someone has not sued for various reasons. They didn't want to sue while their parents were alive because they didn't want the parents to know what had occurred. These are reasons that we have heard over and over again. They do not go to the constitutionality of the CBA, and they do not go to a motion to dismiss.
Well, Your Honor, who else can I see but this court to protect my client's due process rights?
Court of Appeals. Thank you. Thank you both. Last case for argument, Ma v. Wang.
May it please the court? My name is
Yeah, please speak into the microphone. Thank you.
May it please the court. My name is Byung Lee. I represent the appellants. They are the majority trustees of the board of a corporate.
Can I ask you something? I think we've all spent a lot of time trying to figure out what's going on here. I know there's a very long history between your clients.
That's right.
Very long history. I had a question. So I know that this court issued an order in March of last year, of 2025, in which we said that Wei Li Wang could not hold herself out to be the Grand Master pending the determination of the appeal that we're hearing today. So I've been curious, who, if anyone, has been acting as the Grand Master of the CBA since March of 2025? Anybody?
No, Your Honor, because of that order, because it's an injunction order from this court, she stopped. But for a while,
has anybody been acting as like the president, running the day-to-day doings of the corporation, which I know sometimes has been combined with the Grand Master, but is not necessarily?
That's right, Your Honor. It's very confusing. For this temple, it's two lines of management, obviously, leadership.
Got the spiritual, and then you got the corporate.
Spiritual, exactly, Your Honor. The corporate one is governed by the religious corporate law. That's very clear. And that's controlled by the board. That's my client. On the
You've got the two trustees, right?
I represent two trustees.
And are they the only trustees, just two?
That's another
what I
interesting
understand?
thing, Your Honor. Very complicated issue. But yes, at the time of we filed the lawsuit, my client, the two trustees, were the majority members of the trustee because there are only 3 members.
But since then, there have been amendments adding up to, increasing the number of trustees up to 7, right?
Correct. We're back December 2022, and then January 7th, that's the 3rd, we got a membership meeting. At that meeting, that's 3 days after we obtained the TRO from the lower court, enjoined the defendant from acting like not only just grandmaster, but also the president, the everything.
Member, trustee, anything.
Everything, yeah. So we got a TRO there on the December 30th, 2022. And then on January the 3rd, that's like 3 days, we held that membership meeting.
But it wasn't an election. You didn't have an election.
Well, that election, Your Honor, yes, there's the election. There was the election that we elected the chairman of the board. The chairman of the board has to be a clergy member. That clergy member, Your Honor, now answering Your Honor's question finally, became also the religious leader.
And who was that?
That's the Reverend Guang Chuan. The Reverend Guang Chuan. He was the number 2 most favorite successor of Grand Master, appointed by the founding Grand Master. So we only have the 2 Grand Masters here. Grand Master Chen, who's the founding Grand Master when he founded the temple in 1963. Then he passed away in 2019. Before he passed away 3 years ago, we had an amendment. We amended the bylaw to add Article 13.
Yes, we saw
Article
that.
13 says the sitting Grand Master has to name a successor, up to three, not necessarily had to be 3,
Right.
just up to 3. And the current religious leader, Your Honor, is the number 2 successor, favored successor. The number 1 is the second Grand Master who passed away.
So you reject the whole Dharma scroll ceremony where defendant Wang was a successor to Grandmaster Yi.
That's correct. She
You
said that.
reject that whole religious component.
She said that. And the lower court found that she would be the prima facie case on her preliminary injunction, mostly based on a religious ceremony, which the lower court later on said, no, that's not evidence. It's so purely ecclesiastical issue. Well, Your Honor, I don't know if I answered your question.
You do have time on me, but
Maybe
and we can get to the actual.
I have something very important, Your Honor.
I know, but you have time on me, but
Okay.
Thank you.
May it please the court, good afternoon. My name is Jonathan Nelson of the law firm of Nelson, Madden, Black. I represent Wei Li Wang, whose Buddhist Dharma name is Ming Quan, who we assert is the Grand Master,
Based on what?
based upon transmission from the prior Grand Master, Ming Yi.
What about the requirement in Article 13 that the designation by the prior Grand Master has to be approved, has to be followed by an election of the members and then an election by the trustees? Neither of those occurred as to your client, right?
Article 13 is not in evidence in this case below. Article 13 and 14 were at one point presented and then withdrawn during the trial, during the year-long set of hearings that were conducted before the trial judge. And so it's not in the record. It's reflected in appellant's brief. That's where they gave you Article 13. So Article 13 has not been proven in the court below to have been really a part of the bylaws of law. It was not subject to cross-examination, for example.
But first of all, your client wasn't even a member at the time it was adopted.
Your Honor, actually, my client has been a member since 1996. When she was...
Is that in the record?
It's in the record. When she was, ordained by the first Grand Master, by the founder of the temple. And she's been a follower of the temple since that time, although she went off.
She's been a member?
She's been a member since 1996.
But she hasn't been an active member. I thought she lived somewhere else until recently when she came to help the Grand Master who then passed away from cancer. Yeah,
That is true. She was ordained. She became a nun, and then she went off for more instruction. but she remained a follower of Grandmaster Mu-Feng Chen. And then, so when she came back to another temple in the United States, she was also teaching the teachings of Master Mu-Feng Chen. And so when she was brought back to New York by Grandmaster Ming Yi.
When was that?
When was that? That was in early 2022.
Shortly before, I mean,
It was about 6
that
months, I
last year
think.
before she passed away.
I think about 6 months before she passed away.
Right.
She was brought in to be, well, of course, to care for the Grandmaster, but then also to be groomed as the successor Grandmaster by Ming Yi. And we put lots of information in our brief.
So counsel, I'm not understanding your statement that Article 13, it was not a part of the, Article 13 of the bylaws are not a part of the record?
Yeah, Your Honor,
But did not the court base its decision on Article 13?
It did not, Your Honor.
It did not?
I think the court, I think at some point in the court on this decision and not there are two
Right,
appeals
it made
here.
reference to Article 13.
I think, so what happened is that it's still not in the record, but the court did have it before it in the question that it resolved on contempt. But it did not, I believe, at the time when it entered its December
So your
17 order.
position is that Article 13 does not apply and that your client should remain as Grand Master based upon her having been anointed such?
Yes, because for one thing, that's how that's the tradition of this temple. And it's the
How
tradition.
did you establish that?
Well, that was done in the course of a year of hearings before.
But what
the
in the
judge.
record establishes the fact that this was the tradition of this temple?
Your Honor, there
Yeah,
are.
I mean, we are asking the questions because I personally did not see that.
I understand. I'd be happy. I don't have that particular citation. I'm sorry. There's so much in the record. But I do have that on pages 56 through 58 of our brief in the appeal that is number 436. There's extensive discussion of the materials that were supported or that were submitted to the trial court in the course of that year of hearings to substantiate the transmission of the Dharma of the.
So, counsel, again, I'm not understanding this Article 13. I thought that your argument was that the bylaws were not properly amended to add Article 13.
Well, yes, of course.
Okay, so that means that Article 13 does in fact play a role and it was a part of the record, does it not?
Yeah, Your Honor, my understanding is that the attempt during the year-long hearings that led up to the December 14, 2022 order did not include a properly authenticated and
You're not
therefore
talking about
cross-examined version of Article 13.
December 2024 decision by Judge Frank?
I'm sorry, yes, of
Because
course.
there was a hearing that seems to have gone on for a really long time, and
That's the
that's
one.
when he issued his order, right?
That's the one, 2024, I beg your pardon.
2024.
Yes.
So, I mean, has your client presented any evidence that ever acknowledged that she was not a member when these amendments were enacted, but they were enacted in 2015? You said your client became a member when in 1996, but Article 13 says right on the top that it was enacted in 2015. You said she became a member in 1996, so I don't
Right, and she acknowledged, I thought I saw in the papers, that she acknowledged that she was not a member when the amendments were enacted.
She was not present in New
She said
York.
she wasn't a member. She acknowledged she was not a member. She didn't say that she wasn't present. She said she wasn't a member. And also, what you stated previously, that she was a follower, which I was going to ask whether there's a distinction between follower and member. And again, she says that she was not a member when the amendments were enacted.
That may be the source of my own confusion then, but I had understood that she was a member. Something that is clearly in the pleadings is that she is alleged to have become a member in November of 2022. That's in the affidavit.
She claims that she was a member, she has been a member since 1996.
I believe she views herself as having been a member.
Okay,
having been a follower.
I don't know. I am a member of a number of organizations, and I may see myself as a member, but I think the organization would have some determination as to when I became a member, whether I'm a member or not. I pay my dues, that type of thing. So I'm not really understanding.
I was hoping to get an opportunity to argue about the contempt order and a couple of other points, but at least may I make
I'll give you 2 minutes on the contempt.
Thank you. The contempt order was for disobedience of the court's order to give day-to-day management to the respondent.
I thought it had to do with access.
Right.
Well, there are two aspects.
Well, wasn't there a lockout? Wasn't there an alleged lockout?
Well, they allege each way there are allegations of a lockout, but there is not. She has rebutted the allegation that she locked out anybody, and that's also covered in our briefs. But with respect to the lockout that you're talking about, which is that in January of last year, I think.
2025. I think the contempt order is limited to the period of time between the time Judge Frank issued his order in December 2024 and the time we issued an order that changed the situation in March of 2025. So it was a short period of time that the contempt covers.
Right, and so it included the fact that she did not allow defendants access to the books, records, and bank accounts.
The contempt was against the appellants, Your Honor. And the appellants denied her any day-to-day management at all, according to the order, a contempt order that the judge issued. Now, they say that they're confused. They say that they really don't know what the judge was ordering because it's complicated. And so they're saying because the order wasn't unambiguous in their view, they had no reason to comply with it, no ability to comply with it. But they acknowledge, and they've just argued, that there are two types of leadership in this temple. There's the religious side, and there's a corporate side. And that's true in every religious, incorporated religious entity. There's a religious rule, which is the unincorporated religious body, which is led by the religious leaders, and then there is the corporate side, which has to do with ownership.
The rub here in terms of the lockout is that she resides in the temple, whatever, right? That's her home.
That's
her
right.
home is also the temple.
Yes, it is.
She did not allow them access to access.
And their justification for that is that there is someone whom they're calling a presiding master of the temple, who they claim to have appointed, although that's illegal under Section 200 of the RCL.
Don't members require access to the temple?
Well, people certainly who are living in the temple do, and certainly the people who have day-to-day management of the temple have to be able to control their own access to the temple. During the period...
There's a question?
I have a little question. So you're asking us to evaluate whether or not Article 13 was appropriately adopted based on the hearing that was held before Judge Frank. But that would suggest that we would have the transcript of the year-long hearing that happened before Judge Frank. But that doesn't seem to be in the record before us. So how are we supposed to decide that?
Well, Your Honor, the burden is on them to show that Article 13...
Do you agree there's no transcript in front of us?
I do agree. We didn't put that together.
And there's no complete set of exhibits?
That's correct, Your Honor.
Thank you. Go ahead. Thank you.
Thank you.
It looks like quite a few number of points, and very briefly on that.
Counsel, do you agree that there's no transcript and no
Yes, there's a transcript.
comprehensive list of exhibits?
There's a transcript, Your Honor.
I'm sorry?
There is a transcript.
But not in the record?
In front of us.
In front, before this court?
Yes.
No.
That's what I meant by before.
Before this court.
Why?
Mr. Lee, this is essentially a preliminary injunction order that you want to maintain.
Right.
Until the election, determined
the trial.
under Article 13, until
the trial date, Your Honor.
Until the trial, correct?
Very importantly, membership, Your Honor. I found the site. It's in this, the site. Mr. Nelson, with all due respect, is wrong. I just have that, and then all of a sudden, here, Your Honor.
I assume you're only citing to something which is which is in the record before us, because we don't want to hear about anything that is not.
In the record before this court.
In the record before this court.
It's in the record before this court.
Okay, what are you citing from?
Because, Your Honor, that was submitted with my client's motion, Article
Okay,
13.
so what is it and what does it say?
Membership, defendant did not become a member until November the 8th, 2022.
And what is the document in the record that you're reading from?
That's Appendix 459 to 60.
And this is what? What is that?
That's
Her testimony, somebody else's testimony?
It's the late Min Yi submit an application to my clients for approval. And my client responded, okay. November the 8th, record A459 to 60. Mr. Nelson confused with the issue of a follower. Grandmaster Chen had thousands, maybe millions of followers all the world, but they're not members of our temple. They're different. My client, they are also followers of my client, of Grandmaster Chen. There's a ceremony for that, short of ordain, like a cut. The word is tonsure, like you shave your head. Short of that, that's the one issue. The second issue on my news, very important, is about Article 13, not in evidence. It's in evidence. My client testified at trial. Every single one of the protocols.
But we don't have the transcript
Yes,
of the
in there.
testimony.
It's in the transcript. I cited, Your Honor, in my appellate, my opening brief. If you want me, I can point to it. It's in my opening brief and in my reply brief. It's all testified without objection.
Well, we're going to take a look at all the briefs and the transcripts. Thank you so much.
Oh, God. Oops.
Mr. Nelson, let's see you. You know, you give me 1 second about the contempt motion. Didn't give me 1 minute to argue.